2, House Bill number 206, Elections Acceptable Identification Revisions 2. Ayes 49, noes 8, excused 5. Message number 176, House Bill number 177, Statutory Standing Committee Federal Review. Ayes 32, noes 25, excused 5. Mr. President, the following bills passed the House on third reading in an amended form by the vote indicated. Message number 167, House Bill number 31, School Safety and Security, ayes 56, excused 6. Message number 168, House Bill number 60, Student Eligibility in Sports Amendments, ayes 51, noes 6, excused 5. Message number 169, House Bill number 86, Public Property and Buildings Amendments, ayes 57, excused 5. Message number 170, House Bill number 133, Sanctuary Cities, Counties, and State Prohibition, ayes 51, noes 6, excused 5. Message number 173, House Bill number 221, Bighorn and Domestic Sheep Relocation, Effective Date Repeal, ayes 55, noes 2, excused 5. Message number 174, House Bill number 5, Fishing Outfitters and Guides, Registration of Fishing Boats, ayes 35, noes 22, excused 5. Message number 175, House Bill number 164, Medical Prescriptions Off-Label Purchases, ayes 42, noes 15, excused 5. Sincerely, Katie Talbot, House Chief Clerk.
Thank you, Randy. Any standing committee reports?
Mr. President, the following reports are dated February 3, 2025. Committee number 2, Appropriations, to whom is referred Senate Joint Resolution 11, supporting anti-ESG litigation, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman. Committee number 2, Appropriations, to whom is referred Senate File 191, State Funds, Proxy Voting, and Pecuniary Investments, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman. Committee number 2, Appropriations, to whom is referred Senate File 169, Strategic Investments and Projects Account Repeal, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman. Committee number 2, Appropriations, to whom is referred Senate File 141, USMC Corporal Seth Rasmussen Memorial Highway, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman. Mr. President, Committee number 4, Education, to whom is referred Senate Joint Resolution 6, School Capital Construction Constitutional Amendment, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Brennan, Olson, and Scott. Noes, Senators Rothfuss and Schuler. Senator Schuler, Chairman. Your Committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 181, Eminent Domain Energy Collection Systems 2, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Case, Dockstader, Landon, and Steinmetz. Senator Case, Chairman.
Thank you, Randy. Senator Pappas.
Thank you, Mr. President. May I have privilege of the floor?
The floor is yours, sir.
Thank you. Dear Senators of the Senate, we have some special guests with us in the West Gallery. Would you please help me welcome the students, the 5th grade class of the Cheyenne Classical Academy and their principal, Diane Gallagher. Yeah.
Welcome to the Senate, where naps are not only optional, they're recommended. All right, I have a reminder. Second reading amendment requests on the budget bill, Senate File 1, are due today to legal, with the deadline being the end of Committee of the Whole. So don't forget. And then approval of those amendments are due to legal by 10 a.m. tomorrow, Tuesday, February 4th. So once you get them drafted, if you get in by the cutoff, you still have to get them approved on time. If they do not have your approval by 10 a.m., they will save the draft for a potential third reading amendment, so you don't have to repeat the whole process over. Second reading amendments will be considered on Wednesday, February 4th. All senators will receive a packet with a tracking sheet and all number assignments on Wednesday prior to Senate File 1's second reading consideration. Senator Anderson.
Floor,
Floor is
please,
yours.
Mr. President.
Yes, sir.
Joining us in the gallery above your head is Casper Classical Academy, 7th grade. Could we give them a great welcome?
All right, welcome. All right, we better be on our best behavior. Senator Landon.
Mr. President, may I have a quick privilege of the floor,
Absolutely.
please? Thank you for that. You know, like you, Mr. President, over the weekend, I received a few emails. One in particular, I wanted to share with all of you senators. Nice lady there in my hometown wrote the following. She said, you know, I hope you'll keep working hard down there, and thanks for all your efforts. She said, I had to ask you this question. Who is the gentleman who does the readings for the Senate? So I told her who my friend was, and I indicated that he is the Vin Scully of the Wyoming Senate, without question, and how proud we were of him. And I just thought maybe we'd want to remind him how much we think of him, and so does the public. So Randy, thanks for all you do. You're amazing, and we're so lucky to have you here.
The golden voice of the Wyoming Senate. Smooth like butter. All right. I think that takes care of that. Any more privileges or announcements before we kick it to the majority floor leader? Seeing none, Madam Majority Floor Leader.
Mr. President, I move that the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. All those opposed, no. Will the gentleman cowboy please ride to the desk? Senator Landon. Oh.
I'm pinch hitting.
Will the Democrat please come to the desk?
There you go.
All right. All right, get to work.
Committee of the Whole will please come to order. Next bill for our consideration, Senate File 101. Will the reading clerk please read the Senate file?
Senate File 101, Post-Conviction DNA Testing Procedure Amendments, sponsored by Senator Landon, an act relating to criminal procedure.
You have heard the reading of the bill. What is your pleasure, Senator Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 101 do pass. There are no standing committee amendments to this good bill, and I will turn over the explanation of the bill to the gentleman cowboy.
Thank you, Senator Olson. To the gentleman cowboy. Senator Landon.
Thank you, Mr. Chairman. Thanks for being where you are. Appreciate that. And fellow senators, I bring to you Senate File 101. It's one of those bills that comes along. It's happened to every one of us, but we run into friends back home. In this case, it was a constituent of mine who's a member of the legal profession, and she indicated that we have a situation in our statutes, wanted to see if there was something that we could do about it. And that's what post-conviction DNA testing procedure amendments, that's what this bill does. It goes into our criminal procedure title, Mr. Chairman, and under the chapter of appeals and exceptions and new trials. And if you'll notice on the bill, it's the change of a date. And that should mean that it's really simple, but the fact is, Mr. Chairman, it does require a little bit of background to understand why we want to change that date. So under statute 712-303C, convicted individuals must meet a rigorous standard to secure a court-ordered testing of previously untested DNA evidence. The standard is intentionally stringent. It is consistent with similar statutes in all the other states, nearly all the other states, and reflects a careful drafting of the 2008 legislation in the Wyoming statutes. Some of the momentum for that bill came from the Rocky Mountain Innocence Foundation, and the impetus was also in federal law. The issue lies in the next paragraph, paragraph D, which prohibits courts from ordering DNA testing, even if a convicted individual satisfies that high bar that I just described, if the conviction occurred after January 1st, 2000, and the individual did not request any of that DNA testing or introduce any DNA evidence for strategic or tactical reasons. This provision is designed to prevent post-conviction testing from being misused, second chance delay, all of that, and for those who strategically avoided that testing in the first place. So the rationale is sound, but the cutoff date of 2000 creates unintended consequences, Mr. Chairman. Those individuals convicted before 2008, when we finally got around to passing this statute, those convicted after 2000 and before 2008, when the act was passed in Wyoming, it would have been impossible for an individual to make a strategic or tactical decision based on a statute that didn't exist yet. So, enough of that narrative. This bill really is an access to justice bill. It's all about trying to provide redress to individuals who meet those standards but are caught in the middle of those statutory dates. So what we do, we go in with this bill, senators, on page 2, and we bring that date all the way up from January 1st, 2000 to July 1st of 2008. That coincides with the date of the passage of that statute by the Wyoming Senate and cleans up the statutes. I will say just a couple more things about it, Mr. Chairman. There is a case, of course, which brought this to light, and it happened in 2006. And my constituent, as I mentioned, is of the law profession and is looking into that case and representing an individual whom they feel very strongly will be acquitted, but is unable to get any court-ordered DNA testing because of this discrepancy in our laws. This bill has no real fiscal note on it because it's indeterminate. But it is my feeling that you take an individual like that who has been sentenced to life in prison, and let's just say that the DNA evidence is such that he is eventually acquitted, well, that actually is going to make the state some money, Mr. Chairman, because that individual will not be incarcerated for all of that time. But at any rate, it is an access to justice issue. Sorry that it took me a little bit of time to explain this bill, but I think it's a good one, and it'll be a good fix for our statute. So thank you, Mr. Chairman. I'll be glad to answer any questions.
Thank you, Senator Landon. We're on Senate File 101, post-conviction DNA testing, procedure amendments. Any discussion? Senator Ide.
Thank you, Mr. Chairman. I think this is a good bill. I'm honored for this bill. I think this bill helps verify the accuracy of certain criminal convictions. And, you know, it's just good policy. It protects errant convictions on this thing that shouldn't happen. So I think this is a real good bill. Thank you, Mr. Chairman.
Thank you, Senator Ide. Further conversation? Questions? Seeing none, all those in favor of Senator Olson's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation on Senate File 101, please say aye. Opposed, no. Senate File 101 has passed the Committee of the Whole. The next bill for our consideration is Senate File 114. Will the reading clerk please read the Senate file?
Senate File 114, the Missing Persons Reporting Requirement, an act relating to criminal procedure sponsored by Senator Landon.
You've heard the reading of the Senate file. What is your pleasure, Senator Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, that it do so with the recommendation that Senate File 114 do pass. There is a standing committee amendment, which I would ask to be read in at this time.
Senate File 114, Standing Committee Amendment Number 1, page 2, lines 12 through 14.
And I will move Standing Committee Amendment Number 1 to Senate File 114 and ask for your favorable consideration. And then, Mr. Chairman, I think it's probably best that the bill be explained first. And if the gentleman cowboy wants to explain parts of the amendment, he can. Otherwise, at the appropriate time, I'll pick it up and explain the amendment after you got to understand what the bill is doing to understand the amendments.
That's often a good approach. Thank you, Senator
Yes.
Olson. Senator Landon, back to you.
Mr. Chairman, thank you very much. Senators, Senate File 114 is the result of actually quite a bit of work over the last handful of years. And a real tip of the Stetson has to go to one of the sheriffs in the Bighorn Basin, the northern part of the Bighorn Basin, who kind of took this on and played point guard and did a great job of pushing it forward. So it is represented by the group that advocates and explains on behalf of the sheriffs and chiefs of police, for example, out across our state. But it also represents the work of an awful lot of different constituent groups, Mr. Chairman. The bottom line is there's a large body of law and protocol for when a child goes missing, because it is understood that children do not have the wherewithal to protect themselves or make decisions for themselves. However, there's long been an assumption that if an adult goes missing, that it isn't necessarily a crime, because adults do have the wherewithal and they can kind of protect themselves, and sometimes they take off on purpose. So I think that's why, Mr. Chairman, we're a little bit behind on this front. Wyoming, there are about 40 other states, Mr. Chairman, that have these protocols in place. And Wyoming would join those states if this bill is approved. There's a couple things to understand. It's not that law enforcement has been lax in any way. It's just that we have not had perhaps as much communication as is necessary or as much cooperation. The timely reporting and the use of the private sector comes into play on this. So at any rate, Mr. Chairman, that's kind of the background on the bill. I'll take you into the bill real quickly just to understand what it does. Really at the top of page 2, subparagraph A, each Wyoming law enforcement agency shall accept without delay any credible report of a missing person made to a law enforcement agency unless at least one of the following occurs. Now for the next page and a half, all the way through Romanet 7, we give those cases where a law enforcement agency can perhaps not take a report. But the bottom line, that says everything about this bill. We shall accept without delay any credible report, and that agency shall take it seriously. If you go over on page 3, the primary jurisdiction for reporting a missing person shall be the law enforcement agency with jurisdiction over the most recent verifiable location of the missing person. That's also new, Mr. Chairman. On over to paragraph C, all missing person reports meeting the criteria for reporting under this section shall be entered into a relevant national, regional, and state database. Paragraph D, if a missing person is not located within 30 days of being reported missing under this section, the law enforcement agency that accepted the report shall ensure that a complete and accurate record of the information is compiled for the missing person, including a photograph if available. We go on over to the Division of Criminal Investigation, and what we do down in paragraph B is that we amend that language. The division may make publicly available information about ongoing missing person investigations including reports of missing persons submitted to law enforcement agencies under 72109. Mr. Chairman, I've been hurrying through this a little bit just to try to get arms around the bill. That gives you a little bit of background. I think this will bring Wyoming up to a par with all of the surrounding states. Unfortunately, there's a lot of space out in the western United States, and many of our western states lead the nation in missing folks. So we've got to do everything we can to change what's going on out there, and that's what Senate File 114 would do. Mr. Chairman, I guess it would be a good time for us to take up the standing committee amendment, and I would let the chairman do that if he'd like to walk us through the standing committee amendment.
Thank you, Senator Landon. Senator Olson, on the standing committee amendment number 1, and you have moved it.
Yes, I guess it's my turn now. So the standing committee amendment, what it primarily does is makes changes to the list of, there's a list of occurrences that if one or more of those are present, the law enforcement agency does not have to make a missing person report. The first change that it makes is on page 2, lines 12 through 14. The original language of the statute would have required that the missing person not be a resident of Wyoming. We thought that was probably unnecessary. They could be a resident of any other state and go missing in our state, and we would want them to be reported as a missing person. So we just clarified that language by deleting that residency requirement and keeping the second half of the sentence, which reads, the most recent verifiable location of the person reported missing was not in Wyoming. So if it's not in Wyoming, why would we list them as a missing person in Wyoming? And then the bottom of that page, on page 2, there's 2 clauses, 2 options, and there was an and in between those options. And in talking to everyone who had worked on this bill, that wasn't the intent, so that's really an easy cleanup where we delete an and on line 22 and replace it with an or. And then on page 3, one more of the exceptions here. We clarified this language so that it now reads that a person reported missing is being sought for reasons of harassment, stalking, or retaliation. That would be a reason not to list them as a missing person. And then middle of the page 3, we insert the language, or if it's unsafe for the missing person. And that is it. That is the standing committee amendment, Mr. Chairman.
Thank you, Senator Olson. We're on the standing committee amendment number 1. Any discussion? Any discussion? Seeing none. All those in favor of Senator Olson's motion to adopt standing committee amendment number 1 to Senate File 114, please say aye. Those opposed, no. Standing committee amendment number 1 to Senate File 114 has been adopted. We are back on the bill. Back to you, Senator Landon. I see that we have a committee of the whole amendment.
I do, and Mr. Chairman, before I get to that, while we're back on the bill, fellow senators, just to kind of hammer home a couple of points. Wyoming does require DCI to collect missing person data and publish a report, but there's no requirement for our law enforcement out there to accept reports of missing persons. In a few instances, law enforcement agencies may believe that another law enforcement entity is the primary reporting agency, and so therefore would decline to take a missing person report. Law enforcement agencies do not want to duplicate their efforts or enter the same person multiple times. This bill is going to clear up all 3 of those issues. Mr. Chairman, one final thought. I had a right-hand person who helped me with this bill a little bit, and he happens to be here in the chamber with us. I want to acknowledge the work that he did. And I also, those students at the University of Wyoming who do come over and serve as our right-hand people, what a great thing that is, Mr. Chairman. You know a little bit about that. Well, I just wanted to quote from my good friend who is now a university student. He said, "Speaking from personal experience in regard to a missing persons case in Albany County last year, a lot of people felt that there was poor communication from law enforcement in regard to how the case was communicated to the public. UW had a student go missing and there was no communication to the campus community except Facebook, maybe some posts on social media. But at any rate, that's exactly what Senate File 114 is attempting to do, fellow senators. And so with that, I would move the Committee of the Whole Amendment number 1 to Senate File 114.
I don't think we've read that in yet.
Okay, thank you.
Yep.
Senate File 114, Committee of the Whole Amendment Number 1, pages 2, lines 12 through 14, delete.
Now let's get that motion, Senator.
Thank you, Mr. Chairman. I would move the Committee of the Whole Amendment number 1 to Senate File 114. And fellow senators, I want to thank the Judiciary Committee for its work on the bill. What this amendment does, however, is to go back and ask that you reconsider a little portion of the Standing Committee amendment. What that amendment does on lines 12 through 14 is exactly the opposite of what was intended by the language. What we wanted to be able to do was to clarify that law enforcement could refuse to take a report when the person wasn't last seen in Wyoming, only if they were not from Wyoming. Or in the inverse, you shall make a report if they are from Wyoming, even if they weren't last seen here. So I went to our good help, our legal staff, and asked them to take another look at that language. And the fact is, I think the language is correct that was originally in the bill. The idea is that there are times when young men or women who live in Wyoming but were possibly last seen in another state or elsewhere, if somebody calls that in, we want law enforcement to take that report. So it's not all about in the boundary of Wyoming. It's the idea that we want to make sure those reports get taken. So I would ask that you vote in favor of the Committee of the Whole Amendment, and then if we want to revisit this, I'll get with the members of the Judiciary Committee, and maybe we can come up with something on second reading. But thank you.
Thank you, Senator Landon. We're on Committee of the Whole Amendment number 1. Senator Olson.
Thank you, Mr. Chairman. Yeah, no reason to revisit. We think this is a good change. The sentence is a double negative, so it is confusing the way it's written. Probably could be written a different way, but our amendment does the opposite of what the intent was, so I would urge adoption of the Committee of the Whole Amendment.
Thank you, Senator Olson. Any further discussion on Committee of the Whole Amendment number 1? Seeing none, all those in favor of Senator Landon's motion to adopt Committee of the Whole Amendment number 1 to Senate File 114, please say aye. Those opposed, no? Boy, Senator Anderson, you may have carried that one. You were much more vocal than the previous batch. But I'm going to go ahead and say that Committee of the Whole Amendment number 1 has been adopted. We are back on the bill. Senate File 114, missing persons reporting requirement. Back to you, Senator Landon.
Thank you, Mr. Chairman. Appreciate your indulgence. A lot of work has gone into this one. Our law enforcement's on board, nonprofits, our local entities. Glad that we can finally get to this point and hope you'll support the bill.
Thank you, Senator Landon. Discussion on Senate File 114. Senator Cole.
Thank you, Mr. Chairman. Yeah, on and for the bill. I think there's something that wasn't mentioned, and this has to do with the law enforcement system and communication. They've had cases where they had abandoned vehicles that they didn't realize was associated with missing person. And this ties directly back into this whole conversation about notification. So I think Wyoming, is probably high time we update our statutes and make it more easier for people to report a missing person and that person be identified more quickly. Thank you, Mr. Chair.
Thank you, Senator Cole. Any additional discussion? Any additional discussion? Seeing none, all those in favor of Senator Olson's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation of Senate File 114, please say aye. Those opposed, no. Senate File 114 has passed the Committee of the Whole. The next bill for your consideration is Senate File 148. Will the reading clerk please read the Senate file?
Senate File 148, Fire Suppression and Restoration Funding, an act relating to wildfires, sponsored by Senator Crago. It was referred To committee number 6, which returned to committee recommendation that it do pass amended. Ayes Senators Boner, Hicks, Jones, Landon, and Schuler. Senator Landon, chairman. Was re-referred to committee number 2, which returned to committee recommendation that it do pass. Ayes Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Jones.
I move that when the committee of the whole rises to report, it do so with a recommendation that Senate File 148 do pass. And I refer to the good senator to my left. Thank you.
Thank you. Well, to the senator on the left, then, by golly, we'll go.
Yeah, here I am,
Senator
Mr.
Trego.
Chairman. All right.
From my angle, you're right dead center, right?
Yeah, thank you. There you go. Let's keep talking about that. All right, Mr. Chairman, today I bring you Senate File 148, Fire Suppression and Restoration Funding. Ask for the body's favorable consideration of the bill. As many of you know, 2024, as actually everybody in this room knows, and most of Wyoming knows, 2024 was one of the worst fire seasons our state has ever seen. It was particularly hard on people who live and work and recreate in my district, both Johnson, Sheridan County, and also some of our neighboring counties directly to the east. And as a result of those fires, there was a lot of ecological damage to the landscape. There was also a lot of infrastructure damage, both to private and public property. Our state had to spend a great deal of money putting those fires out and addressing other issues that go along with wildfires. This bill is intended to solve some of the problems that resulted from the fire. It's not going to solve all of them, but the intent is to get to some of the larger landscape issues involved with wildland fires. And so we will see this issue come up again in the budget, and some are going to ask right off the bat, so I'm going to answer the question before we get to it. Why a separate bill? Well, 2 reasons. One, I want to back up. I want to back up to the budget, and whether or not it stays in the budget or not, none of us know today. And so this is my chance and my opportunity to make sure that we take care of the issue back home, whether the budget is successful or whether this is successful in the budget. The other reason is there is some provisions in here that I think some people may argue, hey, that's legislating in the budget. It's creating a committee of folks to address the funding mechanism. And so if anybody has that issue, this is their opportunity to vote for the idea without worrying about whether we're legislating in the budget. And so just to walk through the bill, Mr. Chairman, and I will, as we go through, I will point out where we have differences from what is in the budget and what the recommendation was from the chief executive, because there are some differences.
So, Senator, we do have a standing committee amendment, and so just let me know when you want to work that.
Mr. Chairman, if it's okay with you, I would probably get through most of the bill, explain what it's about, and that will allow the good senator from my left over here to explain the standing committee amendment and what the changes are. So if that's okay with you.
I'm pretty sure he's ready, but we'll go back to you, Senator
All right.
Trego. Thank you.
Thank you, Mr. Chairman. So on page 2, and most of the time I go through the appropriations because there's a lot of separate appropriations in this. Page 2, line 8, we are appropriating $1 million back to the Office of the Chief Executive for a special contingency. Those are monies that he expended this year to pay for our firefighting efforts. Line 12 through 15, that's the disaster contingency, 1.2 million, same thing. We are then on line 17 and 9 through 19, putting $30 million into the fire suppression account, refilling that. They're on lines 21 through 23. On the bottom of page 2, we are appropriating $20 million back to LISRA, which was borrowed pursuant to law we had passed last year, pursuant to the budget. And then here's where we kind of get into what is, I'm going to say, is a little bit different than what's proposed elsewhere. This is a $100 million appropriation that would go to landscape, what I'm going to call landscape grant programs. And to be honest with you, the idea of this is to set up a mechanism to pay for weed spraying, mostly ecological, what I'm gonna call preventative measures. As a result of fires, it's likely we are going to have widespread invasive species problems, especially in that neck of the woods. So right now, Sheridan County is full of Ventonata, and they're spending millions of dollars every year to fight that. A lot of the places that burned already have this particular plant species, and it's only gonna get worse with barren ground. And so the idea of this is to create a program where we can treat that. One of the questions is gonna be, well, are we providing funds to individuals? The answer to that is no. We already have a system set up to deal with this. The committee that you and I serve on, Mr. Chairman, deals with this all the time, and that's exactly what this particular appropriation would do. It would set up a 9-member committee that works with the trust fund to figure out how to best spend that money. And so as the next few pages specifically deal with that, you will see that on page 4, the 9-member committee will start with 1 member of the House, 1 member of the Senate, the executive director of the Wildlife and Natural Resource Trust Fund account, board, 6 members then appointed by the chief executive, which would be 1 from his office, 1 from Game and Fish, 1 from Weed and Pest Division of the Department of Ag, 1 from UW Ag Extension Services, 1 person appointed that's a Wyoming County Commissioner, and 1 person from the ag industry. Moving on, moving on, I should say on page 6, we start talking about the process and what the committee, this steering committee is required to do, set up a process for receiving grant applications and also for approving them. Moving down, page 7, line 8, there's an appropriation to pay for the meeting expenses that would be associated with that steering group getting together, reviewing grant applications and approving grant applications. And then, if you see on page 8, this steering committee would terminate on line 7 through 8. Committee would terminate on December 31st, 2026. They would have to report back to the legislature, and that's going to be the subject of one of the standing committee amendments as to which committee they would report. Moving on, there's a transfer on page 9. That's just to pay for all the appropriations contained within the bill. And I need to back up one other thing, and I cruised past that, and I apologize to the body. There's actually appropriation there's an additional appropriation for $10 million to deal with public watershed issues that were created by some of the fires, not only in my district, but in other folks. And that would go specifically to deal with those impacts that the fires had on watershed infrastructure, i.e. water intake facilities, things like that, that were damaged by the fire or could be. And then page 9, and this is also going to be the subject of one of the standing committee amendments. Currently, there's a $30 million borrowing authority put into the bill, and I believe there's a standing committee amendment on that. And with that, I would stand for any questions on the bill or gladly turn it over to the good senator for the amendment, Mr. Chairman.
Any questions on the Senate file before we go to Senator Hicks to explain the standing committee amendment? Senator Hicks.
Mr. Chairman, could I have that read in?
Senate File 148, Standing Committee Amendment Number 1, page 4, line 9, delete.
Okay, Senator Hicks.
Mr. Chairman, I move Standing Committee Amendment Number 1 to Senate File 148 and ask for your favorable consideration. This mostly is just cleanup. There's no substantive changes in here. You go to page 4, line 4. It just places repair and replace watershed habitat with more technically correct language. It says restore watershed health. Page 4, line 10, we deleted facilities and put infrastructure from a standpoint. It may be more infrastructure related than an actual facility that would be eligible for replace. Page 8, line 14, we deleted the Agriculture, State and Public Lands and Water Resources Committee. This deals with the report by the Wildlife Trust Fund Board. It's the TRW Committee, which is the standing committee that receives reports from the Wildlife Natural Resource Trust Fund Board. So just a clarification for that. And then page 9, line 18 is consistent with the action that we took earlier. Just moved the $30 million borrowing authority for the governor to $40 million borrowing authority out of the LSRA in the case of catastrophic need or excessive wildfires in any one year. Thank you, Mr. Chairman.
Appreciate it, Senator Hicks. Thank you for handling that standing committee amendment for us. Is there any discussion on the standing committee amendment? All those in favor of Senator Hicks's motion to adopt standing committee amendment number 1 to Senate File 148, please say aye. Any opposed, no. The standing committee amendment has passed. We are back on the bill. Senator Nethercott.
Thank you, Mr. Chairman. Good senators, I think we need to be paying more attention here. It's that time of the afternoon where we sort of do, sort of don't. But I am concerned about the policy practice of us riding multiple horses and no mechanism to deconflict. So this morning, we passed out very, very similar legislation with $30 million borrowing authority and an additional millions of dollars appropriated for forest fire-related mitigation efforts. This afternoon, we are doing the exact same thing, this time with $40 million. We have our entire supplemental budget, of which its entire purpose before us here this session is fire mitigation, with the governor's recommendation, I think, of over $100 million of proposed appropriation for fire mitigation, and that number is currently being negotiated within the body. So I just want to ask the sponsor, and heard at the beginning of the presentation of this, of the bill, was that I'm presenting it to you out of an abundance of caution, and I appreciate that, but I don't see the caution in the bill. So I'm just curious, will there be a second reading amendment that says, subject to the failure of appropriations to pass in the budget, subject to the bill that we passed this morning? Where are the deconflicting measures, recognizing we are about to spend potentially significant sums of money into the same pot, or tying them up for the same purpose? And so I just think we need to be more thoughtful about acting out of an abundance of caution and have these deconflicting measures in place.
Anything else on Senate File 148? Let's go back to the sponsor.
Thank you, Mr. President, and the good floor leader's exactly right. We are going to have to do that as we move these forward. I've already talked to our good lawyers about that, and that is in the works, but there's more than just this particular bill and other, in the budget, there's several other bills out there that we're gonna have to work on and create language that works amongst all those. And so she's right. That'll be a second or third reading amendment. It will have to be on several pieces of legislation as we move forward. And I just note, this is a lot of money. I am well aware of what we're talking about with this particular piece of legislation. It is a lot of money. But what I also can tell you is if we don't get ahead of that issue and get ahead of that problem, not only in our part of Wyoming, but all of Wyoming, it will cost us a lot more. If those particular invasive species that are prevalent in my part of Wyoming make it out of it, that part of Wyoming, we're all gonna wish we'd spent the money now rather than later. It will cost us exponentially more than this, and that sounds crazy, but talk to any of your weed and pest folks back home and they'll know exactly what I'm talking about. So thank you, Mr. Chairman.
Senator Cole.
Yeah, thank you, Mr. Chairman. Just a general question about why are we standing up a new committee? Why couldn't we do this in the standing committee we currently have? I mean, why do we have this work group? Just what's the logic behind that, and why is that such a better choice than throwing it into a current committee that we have now? Thank you, Mr. Chairman.
Any further questions before we go back to the sponsor? Let's go to Senator Hicks, and then we'll come back to Senator Grego.
Mr. Chairman, I don't have a question because this came through our committee, but I think the majority floor leader makes out a good point. Just by my tally, what's in the budget, what's in the previous bill and this bill is about $372 million. You know, plus a little pocket change here, a couple $100,000, but it's a lot of money.
Senator Craigo?
Thank you, Mr. Chairman. So just to answer the question from the good senator from Sweetwater County, we're hoping we can get these funds on the ground and in use by this fall in our large projects. And they have to go through the committee, they have to be vetted by the legislative committee and then approved by this body and the body down the hall. This would allow us to get some of these funds using a very similar process, but not legislative approval next spring, because a lot of these weeds will need to be sprayed by this fall. And so that's why we set it up this way.
Okay, thank you. Senator Nethercott?
Mr. Chairman, thank you. Wondering if the sponsor could bring some information about how much statewide has been appropriated for invasive species in the last 2 years. As a former member of the Appropriations Committee and a sitting legislator, getting that information is surprisingly very, very difficult. Your local weed and pest districts are generating tax dollars associated with that purpose. The state is appropriating tens of millions, of hundreds of millions of dollars each year. I don't want to intimate by my questioning of the amount we're appropriating to suggest that invasive species and these noxious weeds aren't fundamental to the future of our state, and that appropriating significant resources to combating them isn't critical. I just don't think anyone in this building can give an actual dollar amount for where those monies are going or how they're being utilized. I think each entity that has some money can tell you that, but this challenge holistically from a statewide perspective, of which combating invasive species can only be done holistically, isn't there. So before we continue adding to this dilution of such an important resource for such an important purpose, curious to know if the sponsor perhaps can find that data.
Senator Craigo?
Mr. Chairman, I will get to work on that straight away and see what I can find out. I obviously can do it. We can get the state numbers, as the good floor leader said, and we can reach out to the different districts and see what they have. Those are going to be your big players, and I'll see what I can find out. Thank you, Mr. Chairman, and thank you for the question.
Okay, anything else on Senate File 148? All those in favor of Senator Jones's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 148, please say aye. Any opposed, no. Okay, given the enthusiasm, we're going to have a standing vote here. So all those in favor, please stand. Okay, all those opposed? $15 aye, 13 no. Senate File 148 has passed Committee of the Whole. Next Senate file for our consideration is Senate File 167. Would the reading clerk please read the Senate file?
Senate File 167, Board of Chiropractic Examiners, Criminal History Records, an act relating to professions and occupations, sponsored by Senator Dockstader, was referred to Committee Number 10, which returned a committee recommendation that it do pass. Ayes, Senators Barlow, Crum, Hutchings, Scott, and Steinmetz. Senator Barlow, Chairman.
Heard the reading of the Senate file. What is your pleasure, Senator Barlow?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it does so with a due pass recommendation on Senate File 167. There are no standing committee amendments, and I turn the explanation over to the good Senator Dockstader.
Senator Dockstader.
Thank you, Mr. Chairman. Senate File 167, Board of Chiropractic Examiners, Critical History Records. Folks, this bill is specific for the purpose of protecting the public as part of the healthcare program. On the application for license in the state of Wyoming, it asks about criminal history or convictions, but there's currently no way the chiropractic board can verify if someone has a criminal history that would prevent them from getting a license and seeing patients. Essentially, the board has to take the person's word for it under the current situation. Also, if there is an investigation for a disciplinary action on a license, this would allow the board to check and make sure there are no criminal issues that would cause a licensee to lose or have a suspended license to be displayed in their history. This really is about keeping good players in practice and preventing others that may have lost a license in another state due to a criminal action to come and work their way into the Wyoming system. So with that, just briefly go over the bill, Mr. Chairman. Page 1 allows for the background checks, investigations, and disciplinary action. Page 2 provides the information to the chiropractic board when applying for a license. Page 3 calls for the fingerprinting upon request, and then page 4 requests information on a criminal history. And again, more requests for fingerprinting information. History provides the history as well on page 4. And then on page 5, calls for the disciplinary action. And this applies to initial applicants. Also on page 5, promulgates the rules, creates an effective date. This bill will not see a significant increase. Members of the Senate, again, this simply authorizes the board to have access to criminal records. License applications are subject to investigations under this bill. Disciplinary action comes through the chiropractic board, allows for fingerprinting and seeking necessary information on the applicant. 36 states at this point require criminal background information checks when approving applicants. I ask for your favorable vote.
Thank you, Senator Dockstader. Any discussion on Senate File 167? Senator Nethercott.
Mr. Chairman, thank you. Just more curiosity and a nagging memory of mine that I believe in the Judiciary Committee years ago, we faced this issue for other licensing boards that didn't have the authority to request criminal background checks. And so I recall trying to provide that broad-based authority. Evidently, we missed the chiropractic board. This may be a good topic for an interim to a committee, is understanding which licensing boards that would need to have criminal background check authority don't have that and should. But curious as to how, if there's any knowledge about how they were omitted or how they've been operating thus far. Certainly support the bill and its efforts, just some information.
Thank you, Senator. Back to you, Senator Dockstader.
Thank you, Mr. Chairman. It's my understanding they haven't been able to operate with this. I can't speak to the judicial history of our committee, judiciary history, but they're asking that they have this in place as soon as possible so they can run a better program and make sure that they have qualified people applying for their licenses here in Wyoming.
Okay, thank you. Senator Nethercott.
Mr. Chairman, thank you. At risk of wasting time here, I would direct the sponsor's attention to 719-106 and maybe allowing that chiropractic board faster access to criminal background checks. And that, I believe, is the statute that we modified years ago in order to authorize all of these licensing boards the ability to access criminal background checks. So that new statute that we created years ago is found in Wyoming Statute 719-106. Thanks. I knew I did it.
Has everybody found that statute? Senator Dockstader, any final thoughts on this bill?
Just thank you, Mr. Chairman. Appreciate that broad approach. I'm asking for a specific approach to our chiropractors and their licensing.
Okay, anything further on Senate File 167? All those in favor of Senator Barlow's motion that when the committee of the whole rises to report it, do so with a due pass recommendation on Senate File 167, please say aye. Any opposed, no. Senate File 167 is passed committee of the whole. The next Senate file for our consideration, Senate File 127. Would the reading clerk please read the Senate file?
Senate File 127, Administrative Rules, Legislative Review and Objection, an act relating to administrative procedure sponsored by Senator Boner. It was referred to Committee Number 5, which returned to committee recommendation that it do pass amended. Ayes Senators Crago, French, Ide, McEwen, and Pearson. Senator French, Chairman. Was re-referred to Committee Number 2, which returned to committee recommendation that it do pass. Ayes Senators Driscoll, Garou, Larson, Salazar, and Smith. Senator Salazar, Chairman.
You've heard the reading of the Senate file. What is your pleasure, Senator French?
Excuse me 1 second, the phone's going off in my hearing aids. Having said that,
I hate it when that happens.
I know it. It really messes you up. I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 127 do pass. And for an explanation on that, I call on Senator Boner, and he will discuss any amendments to that.
Senator Boner, and that does have a standing committee amendment and a committee of the whole amendment. So whenever you want to deal with those as well. Senator Boner.
Okay, thank you, Mr. Chairman. We'll start with the bill, then we'll deal with the standing committee amendment, if that's okay with you. Senators, what we have here is Senate File 127. This is a RAIN-style act, RAIN standing for Regulations of the Executive in Need of Scrutiny. And this is fairly descriptive as to what this bill does. So as we know, we're concerned about reducing regulation in this state. And we have a task force dedicated to just that purpose. And I think it's born of the acknowledgement that we do have quite a bit of government services available to our constituents. We hear that all the time as usually a good thing, right, Mr. Chairman? We get the average Wyoming family gets $56,000 in government services, only $4,500 worth of individual tax burden. And that, I'm not disputing that that's a good thing. But, Mr. Chairman, we have to be aware of the drawbacks of those policies, and overregulation could very well be one of them, Mr. Chairman. So I appreciate all the good work that our fellow legislators have done on reducing regulation through that task force. I think there's been a lot of productive conversations that have come of that work. But I point out that all that focus is on the statutes. It's on the work that we do in the legislature. This extends some level of analysis to the things that the executive branch does, which I think is appropriate. It's perfectly within our construct of government, where our founding fathers imagined different branches of government competing with one another. That way we are more likely to leave our citizens alone. And so that's the idea of this bill here, Mr. Chairman. And so to go over how it would work, the basic idea is that for any rule, executive agency rule, to go into permanent effect, and if that rule has more than $100,000 worth of costs on the private sector, so it imposes a cost on the private sector in an amount of more than $100,000 annually, then that would simply require the legislature to approve it. As the bill currently stands, you'll see there's a standing committee amendment that gives us some options as to the best way to actually implement this policy in our state. But as it stands now, there's 3 basic paths in the bill to get an agency rule moving through the process and actually go into effect. Right now, if it's a major rule, it would not go into effect until we came back into session. There's a provision for emergencies, and that would allow a rule to go into effect for up to 120 days without legislative approval. And then there's a third possibility that allows rules that are the direct result of legislation to go into effect immediately, Mr. Chairman. So that's what it is right now. There's a standing committee amendment that would change that at the body's discretion. I thought we'd give some options here. So we'll get to that in a minute. I'll finish up here. It also has a $400,000 appropriation for 2 employees at the Legislative Service Office. These would be economists who would analyze the impact our rules have on the private sector. This is probably the most exciting part for me, Mr. Chairman. We begin to actually put some analysis and some data towards this into looking at the impact that state government has on our private sector. And so this ensures a data-driven decision, Mr. Chairman, and so we can come back here as the case may be, to approve or disapprove those rules based off a cost-benefit analysis. And so once again, Mr. Chairman, the major agency rule definition, that's really important, page 12, starting on line 18, all the way to page 13, line 13. If it doesn't have a cost, even if the rule has a net positive impact on our economy, then we're not even going to look at it. It's only when we have $100,000 worth of costs that this procedure comes into play. And so this will improve transparency, Mr. Chairman. It'll begin to give us another tool in the toolbox to look at the impact that we have and our executive branch friends have on the private sector. With that, you'll go ahead and take care of the standing committee amendment, if that's okay, Mr. Chairman.
Okay, I ask that that be read in, please.
Senate File 127, Standing Committee Amendment Number 1, corrected copy, page 4, lines 1 through 11, delete.
Senator Boner, Standing Committee Amendment, can you walk us in and out of that one?
Yes, Mr. Chairman, I move Standing Committee Amendment Number 1 in Senate File 127, and ask for your favorable consideration. Ladies and gentlemen, this is a policy choice before us, how we want this to actually work. If you approve the Standing Committee Amendment, substantively what we're doing is saying that any and all rules, even major agency rules, can go into effect just like they currently do. The difference would be that when we come back into session, for them to continue to be in effect, if it's a major agency rule, we would have to vote that up or down. And so I would submit to you that this is a better choice. This is a better fit for our citizen legislature, and make sure that everything operates a little bit more smoothly, Mr. Chairman. And so with that, I think this is a pretty major policy choice as to which way we want to go. I submit that this is a much better way. There's also an incorporation of some feedback we got from the Secretary of State's office that changes the timeline for the LSO to submit these rules from 60 to 50 days. That's due to the fact that there's a 10-day gap currently between when the agency has to submit it and when we may see it over here. So that's more of a technical correction to make sure that we comply with the intent of a 60-day timeframe. So that's the amendment, Mr. Chairman. I'll stand for questions on the amendment.
Okay, we are on the Standing Committee Amendment to Senate File 127. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I'm not entirely sure what the contrast point was in the amendment relative to the bill. And actually, what I think I'd appreciate would be a walkthrough of the bill so we can really understand what it does in its current form, and then the contrast with the amendment. There's a lot of complexity here. I understand that the amendment says that there has to be an up or down vote, but I don't have enough understanding of the process that's in place right now to really see how that's delineating. So if we can just maybe walk through the bill a little bit. I understand the concept of the bill. The overview was excellent, but going through the details of the bill and then contrasting it with the amendment, I get the 50 versus 60.
Any other questions or concerns before I go back to Senator Boner on the Standing Committee Amendment? Senator Boner.
Okay, thank you, Mr. Chairman. Sorry that wasn't too clear. So I'll start off with the definition of the major agency rule. As I said, that's on the top of page 12 to the bottom of line 13. That's really the key concept here. That's the, I guess, the trigger mechanism, if you will. It determines whether we're going to have any say at all, whether the rule is subject to these procedures or not. And so start there, even though it's not necessarily at the beginning of the bill, but I think that's the first concept we really need to look at. Currently, right now, a major agency rule shall be reviewed and not go into effect unless both chambers vote for it to go into effect. And so that's the idea behind the bill as it is now. So we'd be on hold. All the rules would be on hold. Major agency rules, not all the rules, until we get back into session. Now, a little bit more detail as to how that works. We have a chief economist at the Legislative Service Office, which would provide the analysis. However, it'd be Management Council that makes that ultimate determination. And so you see that process starting on page 2. Then on the bottom of page 3, that's when it says that we should ratify or reject the major agency rule at the next session. Important note that if we get a rule in the middle of the session, if it's within the last 15 days of the session, that'd be kicked to the next one. So important distinction there. There's a provision for emergency rules if you're going to delay implementation of a rule. I think it's clear that you have to have some ability for the governor to respond to an emergency. That's going to be on page 4, lines 17 and 22, as well as page 5, lines 15 and 17. So if this happens, the governor has to justify why it's an emergency rule, and then it could be in effect for up to 120 days. And so we allow for that provision, for that to actually, so we're not completely hamstringing the executive if there's a good reason for implementing a rule. But once again, it's only good for 120 days. And then page 7, line 9, Mr. Chairman, you'll see there's the provision for rules that are the result of legislation, and those could go into effect right away. You'll see on page 7, there's some detail as to what goes into the analysis. And I think that's really important when we start talking about cost benefits at the top of page 9, line 4. So you'll see that subparagraph 4 and all the subparagraphs based off of that. We're looking at the primary or direct benefits. The cost savings, it's possible that maybe this rule saves the private sector money. We want to make sure we take that into account. And so that's why we have some economists that we'd be hiring for the LSO to make sure we conduct that analysis. And then once again, that'd be submitted to Management Council. So 3 different possibilities. Once it's submitted to Management Council, they determine it's a major agency rule. And at that point, if it wasn't an emergency, it would be delayed. It would not go into effect until we come back into session. If it wasn't an emergency, it could go into effect, but we'd have to approve it some way or another within 120 days. And then the third possibility is that if the rules were promulgated as a result of legislation, then they could go into effect as normal with the requirement for the legislature to still come back in and approve it. So I hope that makes it a little bit clearer what the current process is in the bill. What the standing committee amendment does is it makes it so that all rules can go into effect. And I think that's a little bit smoother, Mr. Chairman, but still have the requirement, if it's a major agency rule, that we come back in and approve it, majority in both chambers, for it to continue to be in effect after we come back into the session. So I hope that makes it a little bit clearer. Thanks for slowing me down, I appreciate it. And so that's, if you vote for the standing committee amendment, I'd argue that it makes it a little bit more streamlined, still accomplishes the intent, but without the unintended consequences of, say there is a legitimate emergency and for whatever reason we can't approve it within 120 days. I think that this works quite a bit better if we go with the standing committee amendment. I'll stand for further questions.
Thank you, Senator Boner. We are on the standing committee amendment number 1 to Senate File 127. Any other discussion? All those in favor of Senator Boner's motion to adopt standing committee amendment number 1 to Senate File 127, please say aye. Any opposed, no. The standing committee amendment has passed. We do have a committee of the whole amendment. Senator Boner, do you want to handle that one? Senator Boner.
Senate File 127, Committee of the Whole Amendment Number 1, page 4, lines 1 through 11 in.
Thank you very much. Senator Boner, go ahead.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1, Senate File 127, ask for the body's favorable consideration. Mr. Chairman, what this does, this is a good technical catch by our staff. I want to allow for the possibility that we have a delayed effective date in the rules themselves. And so that's all that this does. It strikes a major agency rule may take effect and inserts, unless another effective date is specified in the major agency rule, it shall take effect. So a good catch by our LSO staff, and stand for any questions on this one.
Any discussion on the Committee of the Whole Amendment? Any discussion? All those in favor of Senator Boner's motion to adopt Committee of the Whole Amendment number 1 to Senate File 127, please say aye. Any opposed, no. The amendment has passed. We are back on Senate File 127, discussion. Senator Nethercott.
Thank you, Mr. Chairman. Struggling to understand what we're trying to solve. I appreciate that this is a national agenda bill, trying to be a pre-formulated bill for Wyoming, trying to be adopted in all 50 states, with the failure to recognize that Wyoming is not those other states. I find that deeply disappointing. I find it incredibly ironic that for a policy position of less government, we are actually growing it with the bill by adding 2 employees to our costs. We need 2 employees to check in order to slow down large projects. I am not hearing a lot of complaints from industry concerning state rules. Typically, those state rules, in fact, I don't know of any state rules that aren't promulgated without legislative authority. Bills that we draft and authorize those state agencies of which we have oversight for in order to create and authorize those rules for industry to operate and do business in Wyoming. The last I heard was Wyoming is open and ready for business, and the rules that we promulgate through our lawmaking isn't the reason why we're not. And so I'm going to need to understand why growing government and slowing down the cost of doing business so that we legislature can come back and say, yeah, great job, state agency, you did what we asked us to do in our original legislation authorizing you to promulgate rules. This is an out-of-state solution seeking a Wyoming problem, slowing down our business and growing our government. Vote no.
Senator Drew, and then we'll go to Senator Steinmetz.
Thank you, Mr. Chairman. As a immediate past co-chair of the Regulatory Reduction Task Force, one of the tags we got a lot when we were going through trying to get rid of regulations, the knock on us was that we seemed to keep adding regulations and trying to solve problems. And when I look at this bill, I too want to achieve that. I want to achieve the goal of making government more streamlined. But as I stand here, I know that if I, as a member of this body, once we pass a law and it says promulgate rule, that we ask someone to promulgate rules, I can get a copy of those rules, as any member can. As a member of the Management Council, you automatically get a copy. As a person from a committee where the bill came from, you automatically get a copy. But anyone else can ask for a copy, can question the rules, can question the people that wrote the rules, and even, I think to a point, can even put a hold on them until those questions are answered. Given that, and then what the previous speaker just said, I want to be for this bill. Actually, I want to be for making things more streamlined. We've got the best tax climate in the country for new business. We've got the most business-friendly climate. It's been published in magazines and periodicals across the country, Mr. Chairman. So I know that because I see it, and I think this body's, to its credit, has been a big part of that. So I'm searching for a way to be for this bill, and I'm searching for a reason to be for it, but I'm just having trouble getting there, and I know it's first reading, that's what we're here for. So just a little more discussion on that. I want to hear from the other folks around and see what they're thinking about it too. I appreciate it, Mr. Chairman. Thanks.
Thank you, Senator. Senator Steinmetz, and then we'll go back to you, Senator Bowen.
Thank you, Mr. Chairman. On and for the bill. Mr. Chairman, just a brief history lesson. We used to have an agency within the governor's office, the chief executive's office, it's probably been 15, 20 years ago, that did a review of all regulations, federal, state, all of that, and how it affected our industries. The good senator from Bates Creek probably remembers all about this. But I had considered running similar legislation because our state in some ways has become an arm of the federal government. You want to talk about out-of-state influences coming into our state. We have been having regulations raining down on top of us, especially for the last 4 years. And I think this is a good measure to put a check and a balance on that and see what our federal partners are putting at our feet and how our agencies are responding, as well as things that we pass, and make sure the agency is responding accordingly of how we wanted this implemented. And so this is a good government measure. It is an accountability measure, and it is much needed in our state. And I thank the good senator for bringing the bill.
Let's go to Senator Boner, and then we'll come to Senator Ide.
Thank you, Mr. Chairman. I'm glad we have this discussion. I did look at this bill, but it has been successful in other states. I hope we don't hold that against this piece of legislation. And I'll just tell you a story about my neck of the woods, where maybe we have a different view of state agencies than other parts of the state. I have a constituent who's in the power supply business, Mr. Chairman. He provides power to oil and gas locations in particular. And there was a new rule promulgated by our Department of Revenue that would further define, I guess you could say, when sales tax on his labor was appropriate and when it wasn't. It was 150 feet of the oil and gas pad. It was after the well had been fractured. And so there's a very specific compliance as to when he was allowed or required to charge sales tax and when he wasn't. Now, as a locally owned business, he didn't have the ability to distinguish between when those situations were relevant and when they weren't. So he just charged sales tax in every circumstance because he didn't have a large regulatory compliance division in his locally owned business. And he lost some bids, 5% sales tax in Converse County. Some bids he lost by 3% to a larger out-of-state competitor. So the point of the bill, yes, is to slow down rules and regulations. Absolutely. That is the point of the bill. I have to remind the Senate, it's only in the circumstance where it is imposing a cost on the private sector. That's it. All other rules are not affected. Since we adopted the Standing Committee Amendment, all rules are going to affect anyways. We just come in and we approve it. To my colleague from Teton County, let's highlight the differences between this policy and the policies we have in place. It's true, if we pass a law that requires rulemaking, we get some communication back from the agency. We have the ability to provide input, and ultimately, we have the ability, though we've never used it in my 10 years here, to object to a rule that is a result of legislation if that rule is completely outside of our intent when we passed it. And I'm familiar with this because, frankly, I won't get into the details. We had to take a pretty close look at it about 2 years ago with a bill that I was the prime sponsor of, where the agency simply was struggling to implement the clear intent of the statute. And we came fairly close to the process that we do have to basically nullify that rule. This is different, Mr. Chairman. This affects all rules, not ones just the result of legislation, but all rules that hit that $100,000 threshold. And so it also requires more input from us, frankly. I think maybe the legislature could probably do a little bit better job. I appreciate the input from my friend who's been on management council. I know I've gotten those notices. I haven't always looked at them very closely. This requires an economic analysis of all rules, not just ones as a result of legislation, Mr. Chairman. I think that's going to be a very helpful and useful exercise. We have one of the smallest, if not the smallest, legislative branches in the entire country, and that's in contrast to a very significant executive branch, going back to the original amount of government services we receive. It's above average, I should say. So just a reminder that we see over 100 rules a year. To employees, it's the bare minimum you need to conduct the sort of analysis according to our Legislative Service Office. This is a basic thing that we can do to, yes, slow down our agencies and make them think and conduct a thoughtful analysis when and only when they are going to cause a cost on our private sector.
Senator Ide, and then we'll go to Senator Anderson.
Thank you, Mr. Chairman. Good discussion here. Good majority floor leader brought up things that I always consider on everything. Growing government spending, appropriations on things always give me heartburn. But this bill here, I think it has some merit. I mean, it's a good step toward, what the bill says, reining in the administrative state. And, having legislative oversight. What that would revert to I don't know how you measure it, but, less regulation and more freedom is what we're all looking for here, or at least that's what I'm looking for here. And I think, every law, I don't even like the $100,000 minimum. I think it should be zero in there, that everything, any of these regulations come through this body effectively. So we're the ones that make the laws. So I'm on and for the bill. Thank you.
Senator Anderson and then Senator Cole.
Mr. Chairman, not for or against the bill, but I'm amazed that we're talking about slowing down our agencies. Everything I've heard in the last 12 years is speeding them up. And we've given them money for more people to speed up their activities. And we ask that they not hold up our private enterprise and not hold up any kind of things. And we're not trying to slow them down. As the senator from Garden Creek is prone to say, I don't like more government regulation like this is, or more paperwork. And so I don't see this as a good bill. Thank you.
Senator Kolb, and then we'll go to Senator Rothfuss.
Yeah, thank you, Mr. Chairman. I'm speaking in favor of this bill, and it's the concept of what I'm speaking in favor of. I mean, we hear about all the government agencies are creating great rules that we all agree with. Well, we obviously know that's not true. I think, frankly, they're bureaucrats, and they have good intentions. Not saying anything negative about their intentions, but they know what they know, and that's to continue on long after we're gone. This is an attempt to rein in some of the rules, and I haven't been only here for 4 years, but I've certainly seen a lot of rules that turned out a little differently than I would have thought they would have turned out. And they did them with good intentions. Department of Transportation is probably an easy one to talk about. They promulgated rules, and you're like, well, why'd you do that? Well, because of some other reason that had nothing to do with the legislative intent. And I think this is an attempt to probably have more balance. Obviously, we're not a full-time legislative body. We're not here all the time. But I think any of these large decisions that do not benefit industry, all those regulatory task force items that came up, those in fact were because of over-regulation, because of rules. And we come to find out the only reason why they did it was something outside of what the intention was. And so they reined it back in again once there was a discussion about why we're doing it. WYDOT rules about CDLs, why do we do it? They go to a national conference, it's all done with good intentions, and the end result is more regulations that we don't need. Then we're embroiled in a conversation about, well, what do we do now, and what can we do? And after consideration with the, conversation with the department, they'll generally rescind them. But that's the battle here. It isn't about good regulations. It isn't about speeding up the process of an approval of some permit. Obviously, that's not a good thing to slow it down. But if we had only good rules we were talking about, we wouldn't be here talking about this. This is about the instance where in good faith, they develop rules which I think run contrary to what the body would have liked to have happened, which is speeding up the process, which is helping industry, which is helping the state of Wyoming grow. And if I thought all those things were just great, I don't think we'd be discussing this. And as it pertains to the two people necessary in this department, growing government in that respect, well, I think we need a conversation about that. Is 2 the right number? Is 1 the right number? Do we need people Do we really need to have more folks doing this? But I'd like to get this through committee of the whole. I'd like further discussion on this. I think it deserves merit, this concept that we're talking about here. And it's a first step towards, I think, streamlining government and streamlining what we have good intentions in doing, which is promoting industry in the state of Wyoming. Thank you, Mr. Chairman.
Thank you, Senator. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I have concerns with this legislation, and, as we talk about the process, I think it's important, as has been pointed out a little bit, to think about what the process is that we have right now. And also to think about how few of my colleagues have engaged in the process. All right. We're complaining about rules and how the rules are promulgated. Everybody in this chamber has full access to every step of that path on the rule promulgation. Our Legislative Service Office, Mr. Chairman, and you know this as well as I do, spends an unbelievable amount of time reviewing rules because we write legislation that has the phrase, the agency shall promulgate rules and regulations to implement this, blah, blah, blah. If we didn't write that, there actually wouldn't be any rules, but it might be a little bit confusing. But we write that all the time. We're delegating legislative authority to the agency because it's too hard to write really, really good legislation. So our Legislative Service Office spends, it's probably not quite half of their time, but really a significant amount of time. Many members of our staff are going through this and making sure that what is being implemented by an agency fits into what the statute says. And if there is a non-compliance, that's flagged. And you know this as well. It's flagged to Management Council. If there is not a non-compliance in our legislative staff review, then it doesn't get flagged. It goes on what's called the consent list. And then, unless you want to object, it's going to be approved. But you're always free to object, and you're free to read those. Any member of this chamber could just say the words, I would like to receive all of the rules to our LSO. And I know them well. They will send you all of the rules. And you can scrutinize them, but you won't. Because it's an unbelievable amount of work to go through it all and see if it aligns with statute. And most of the time, it's going to. So this idea that our process is flawed and that we have people just out there making rules that don't align with statute, I believe is inaccurate. And to my good friend from Converse County, I think I remember during my time on Management Council about 4 or 5 times when the legislature objected. I was trying to count some. I came up with 3 clear examples, but that was all I could come up with, where we explicitly objected. Another time, Mr. Chairman, and you serve on this committee and have with me for a long time, Select School Facilities, we read a draft of the rules and we called the agency in during the interim to present those rules because we did not believe they complied with statute. And this is a shocker. It all changed in consultation with the Select Committee, and then at the end of the process, those rules aligned with statute. And they went into effect. All of the mechanisms that this calls for are in place. And you may think, well, except for this up or down vote. Well, here's an idea, Mr. Chairman. We're a legislature. So by the time rules that are adopted during the interim get to the legislative session, we are duly empowered during the legislative session to pass a law to override the rules, or to change them, or to change the law, or to change their interpretation. And I hope everybody in here who's been here for a few years can remember a time when we did that, because things turned out differently than we expected. It was compliant with the law, perhaps. Maybe it wasn't compliant with our intent, so we changed it. So the idea that we need to violate the separation of powers side of this and say that we have a required approval process where the legislature has to serve in an executive capacity to approve, right, that's a violation of constitutional separation of powers. But it's not a violation if we simply legislate the change in the same timeline, literally the exact same timeline, but it doesn't slow down that process. So, Mr. Chairman, there's nothing in this bill that we can't already do and don't already do incredibly effectively. And really, I encourage members of the chamber that are concerned about this bill, make the ask to LSO. I want you to. Just spend a few months on that listserv, read all of the rules, and then come back and tell us all about your experience at the next legislative session, because it's excruciating. Yeah, many people have. It is not a pleasant experience. It is wonderful that they flag the ones that are non-consent list, and then you get one of those every few months instead of 1,000 rules seemingly. Mr. Chairman, when we talk about business in the state of Wyoming, we have really emphasized and prioritized regulating to enable rather than regulating to restrict, trying to build a regulatory structure that provides ease of engagement for our industry. I'm not hearing on the Minerals Committee anyone coming up and saying, you know what we really need is this particular piece of legislation. That's not happening. In fact, I suspect that if I went out to those stakeholders that come to the Minerals Committee and said, do you want us to add another layer to our rulemaking process? I'm going to guess they would all say no, because they don't want to increase the bureaucratic barrier. They want to increase the efficiency, and this goes contrary to that. The process now might not be perfect, but it is far faster and more responsive than the system that we're looking at implementing, and the process right now is constitutional. We need to be very concerned about this bill. And again, I understand the idea that we all want to be the executive branch and the legislative branch. I don't see anything in here where we're trying to be the judicial branch, but I'll read it again. But we are delegated the authority through the Constitution to legislate. And we have to make sure that we're staying in our lane, and this bill is swerved right out into the barrow ditch that you often talk about, Mr. Chairman. Thank you. On and against.
Thank you, Senator. Senator Boner.
Thank you, Mr. Chairman. Lots of ground to cover there. I'll start with the separation of powers issue. If this bill doesn't do anything different, then maybe we're already in, violating the separation of powers. I'm confused about which one is true, which one isn't. Either we're violating separation of powers or this bill does nothing. It can't possibly do both. I'd just remind the body what this does and why it is different from our current process. I think that's worth reviewing, because this only comes into effect, Mr. Chairman, if there is a substantially negative impact on our private sector. That's it. We're not talking about rules that are business friendly or so great they're going to help private businesses. Those don't apply. That's part of the economic analysis as a part of this legislation. So it's only rules that impose a cost on our businesses that are going to be reviewed for approval. I can't say that enough. I have to say I'm a little frustrated that apparently we just want to ignore that aspect of the bill. It's the most fundamental part of the bill. And I agree that we haven't done a very good job, once again, of reviewing these rules and making sure that we're doing our job, not just for rules that are recently promulgated as the current process allows for, but for all rules that are a result of legislation could be 10, 15, 20 years ago. It's important that we have that ability to go back and check and make sure that it's still relevant today. Maybe the problem is the statute. We need to know that. The economic analysis is critical. We need to understand the costs we impose on the private sector. Between that and expecting more out of this branch of government too, and protecting the private sector from undue regulation. Those are the keys of the bill. That's why I ask you to support it. Mr. Chairman, I think we have to take a hard look at ourselves here. We have a very low individual tax burden. That's right. But if that's so great, if we're so business friendly, why is our population growing so slowly compared to all the other mountain states around us? Why is our economy not diversified yet? It seems like that's been a constant mantra for several decades now. I think it's okay to consider a different approach. And if it comes out that everything's peachy, everything's fine, we don't have anything to approve because they don't meet the $100,000 cost requirement that requires approval, then that's fine. I point out that there is a delayed effective date also, Mr. Chairman, July 1st, 2026, so we can determine how this is going to work, iron out any kinks. It's a big change, and begin to conduct that analysis, Mr. Chairman. So on for the bill. I think it's an important step forward.
Senator Nethercott.
Thank you, Mr. Chairman. What I've heard from those in support of the bill is it has a good intent. Well, I believe that every bill that is filed by a senator has a really good intent. I don't doubt that for a second. I believe people are trying to serve their constituents and do right. I do believe that this bill has a good intent. I believe that reducing regulation is an excellent intent and one that I support. But this bill doesn't work because it's an out-of-state solution seeking a Wyoming problem. Here's why. The bill completely disregards how the rulemaking process works, which does not happen in a vacuum. There's an entire rulemaking process where it's noticed, then there's a public comment period, then that agency takes those comments into consideration, which includes our own. And so we have to take responsibility for our own inaction. We've admitted already in this chamber, we have conceded that we are not participating in that process. And our solution for it here is adding more government employees. Should we put on the notice of their positions that are hundreds of thousands of dollars annually, that this position may expire in 2 years? Please come take this job. And do we really need that level of expertise to do an economic analysis on a rule that may have a $100,000 impact on an industry? That's probably apparent on its face. This is an artificial solution seeking a problem. The intent is brilliant. The intent is excellent. And I believe that this solution would be appropriate in the Management Audit Committee of which this legislature created, whose primary purpose it is to evaluate our state agencies and programs to make sure that they are operating efficiently. Wyoming has already created a solution to this problem within the legislature's control. Again, the intent is very good, and absolutely we should be mindful of those rules that we have failed to participate in, that have had a negative impact on industry, of which I have not heard of any, which I think is important, that those on the Minerals Committee hearing from mining, oil and gas, solar, wind, all of the energy industries are not saying this is a problem. I think that's important to understand how it would slow it down. So one thing that's not being discussed is how would it slow it down? How long does it take to get that economic analysis impact? What if the industry wants to object? What if the agency wants to object to LSO's interpretation of that agency impact? Are we really turning this into a bureaucratic nightmare under the guise of government efficiency? And I think that we are. I think there's probably more elegant solutions out there to solve this concern. Again, I too appreciate the intent.
Further discussion, Senate File 127. Okay, let's go back and maybe Senator Boner, you can take us home on this.
Okay, thank you, Mr. Chairman. Appreciate the good discussion. I'm glad we brought up the Management Audit Committee. That's a committee that used to have equal stature to Management Council. And I was the vice chairman of that committee when we conducted a pretty tough review as to, whether we're going to continue those functions. And, I think that, I definitely had that function in mind when I was crafting this bill. I think it's a shadow of its former self, Mr. Chairman. I hope that we can move this bill forward. Once again, it's only going to add complications if the rule negatively affects the private sector, and that's it.
Thank you, Senator. Are you ready for the question? All those in favor of Senator French's motion that when the Committee of the Whole rises to report it, do so with a do pass recommendation on Senate File 127, please say aye. Aye. Opposed, no. No. Senate File 127 is passed Committee of the Whole. The next Senate file for our consideration is Senate File 111. Would the reading clerk please read the Senate file?
Senate File 111, net metering revisions, an act related to net metering, sponsored by Senator Case. It was referred to Committee Number 7, which returned a committee recommendation that it do pass. Ayes, Senators Case, Dockstader, Landon, and Steinmetz. No, Senator Boner. Senator Landon, acting chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Case.
Thank you very much, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with a do pass recommendation on Senate File 111, net metering revisions. Mr. Chairman, thank you very much. We've been down this road a bit before. We've had success in moving this issue through this great body, but our friends down the hall sometimes don't see things exactly like we do. But this time I think they will, Mr. Chairman. I've tried to really bring a bill that's important to Wyoming, that's good for Wyoming, and I appreciate your indulgence. I did have a handout that was passed out that kind of talks about what we're talking about. It's got my name up at the top. You know, and here's the basic problem here, everybody, is the fact that you might think that you pay at your home, when you think about your electric bill, you pay a monthly charge and then you pay a charge for energy. And you think the monthly charge covers all the fixed costs, and you think the energy charge covers the cost of energy. Well, it's not really that's not true, Mr. Chairman, and that's the big problem. It's not true at all. In fact, in this fine, fair city of Cheyenne, the energy charges on a per kilowatt hour basis actually collect only about 24% is for energy, but 76% of the per kilowatt hour fee is for the fixed costs of the electrical system. That's the problem. And that's the problem we have to work on. So the rooftop solar situation, or net metering, kind of forces all of the customers to buy utility energy that's actually the most expensive energy at all. And so what happens, Mr. Chairman, is that it's a very seasonal thing. People produce a lot of energy in the summer when rooftop installations get a lot of sunlight. You know, 2/3 of the sunlight is in the summer months, only like 1/3 in the winter months, if you compare like June to December. And so the problem is people produce a lot of electricity when it's not really needed, because every solar installation, including this huge one south of Cheyenne now, is going to be producing very inexpensive energy in the summer. That energy is so inexpensive that sometimes it comes on the market at a negative price. Unbelievable, but it's absolutely true, because there's just so much of it. In the winter, it's a different problem, Mr. Chairman. In the winter, we're scrambling for solar energy, and it doesn't come about. It's at least 30% less productive. The hours of daylight are much less. The sun's lower on the horizon, so December production isn't very good. The way net metering works, Mr. Chairman, is it accumulates a balance over the year. So that big balance you get in the summer can be chewed up each month as it goes through, and finally it might go negative. If you design your system to be working perfectly by having enough solar panels, and you work very hard to make sure they're producing the best they can, you might get an energy cost of zero, a kilowatt cost of zero for a year. Okay, Mr. Chairman? But your neighbor has a positive charge. And you say, well, that's just fair. You made electricity. Go back to that first part when I was talking about how those kilowatt hour charges recover fixed costs. In the end, after a year, you may pay zero towards the fixed cost of the electricity system, while your neighbor pays the full deal. Your very neighbor. Now, we're not talking about hurting the utility here, Mr. Chairman, because utilities are rate regulated. When things get out of whack, they go down to our friends at the Public Service Commission and they say, we need to recover our cost, this is our cost, blah, blah, blah. And the commission really has to grant. You can't take utilities' property away from them. You have to give them a fair rate of return. So, Mr. Chairman, let's use a real-life example for the city of Cheyenne. According to the Energy Information Administration, the average homeowner uses about almost 900 kilowatt hours of electricity a month across the country. I don't know for sure how Cheyenne matches with the average across the country, Mr. Chairman, but I'm using a rough number here. You all can think of your utility bills at home. I thought, well, this isn't too far off, is what I kind of came out on that. And so in Cheyenne, they have kind of high rates here. They're working on it, but it's over 14 cents a kilowatt hour, Mr. Chairman.
So that works out to be, for the average homeowner, they have an electric bill that's about $1,500 in a year. It's a pretty big electric bill, but that covers both the cost of energy and the cost of fixed costs. 76% are the fixed costs of the electricity system, Mr. Chairman. Now, what if you had a very well-designed solar system on your house next door, and you, in your household, you consume the same amount of energy, but you also produce that exact same amount of energy, Mr. Chairman? Well, then you would pay zero towards the fixed costs, but your neighbor without the solar panels, they'll be paying 76% of $1,500, or $1,166.29, Mr. Chairman. That's assuming average electricity use in Cheyenne as the rest of the country. That's a huge difference. Over $1,000. So you wonder why it's so lucrative, and people are very impassioned about this investment they've made. And they've made some big investments, Mr. Chairman. We've heard of systems costing $50,000 or more now. And they're very proud of it. And they point out to us that they're doing it for reasons of energy independence. Well, let's talk about energy independence. They're not really independent because on that December day when the sun don't shine or it's 4 o'clock in the morning, they need as much electricity as the guy next door. And so they have to use that system just as much as the guy next door. The other reason they say is they want to, it's often said it's a way for them to cut their electric bill and to stick it to the man being the utility, Mr. Chairman. I've already talked to you about the rate process, and this doesn't hurt utilities. This comes out of other customers who have to pay higher rates to cover those costs. So they might be shaving their electricity costs, they sure are, by $1,166 in that average case for a perfectly developed system. But they're not really sticking it to the man. They're sticking it to their neighbors and their friends. And Mr. Chairman, the third thing you often hear, it's a good reason, is that I'm doing this to reduce my carbon footprint because we have a crisis and we need to do something about it. I agree with that, Mr. Chairman. I do believe there's CO2 and global warming is a crisis. But I'd like to point out to you, Mr. Chairman, that we're doing it in the most expensive way possible that we can. And if you look on a chart I handled out, there's a bottom that's got a comparison of different electricity rates. And the levelized cost of energy, the highest one, Mr. Chairman, is rooftop solar under a net metering arrangement. One of the lowest ones is utility scale solar. The difference is pretty astounding. And here's what happens in the summer. When they're producing all that energy with their rooftops, the solar farm south of Cheyenne is going to be producing a lot of energy too, and solar farms in Las Vegas and in California, they'll all be putting it on the grid. That price may actually go negative. It'll go very close to zero. But we can't take that electricity because we've got to take the electricity from our neighbor because it's going into the grid and there's no way to stop it. So we got to buy his electricity first. In Cheyenne, you're buying it for 14 cents a kilowatt hour, when it might be available from large-scale installations at a negative price. All right, is that attacking the carbon dioxide problem? It's kind of doing it in a pretty expensive way, Mr. Chairman, and when you look at the cost of the $1,166, and you try to say, well, how many tons of CO2 might have been removed? And you have to kind of estimate how energy is produced and how much CO2 is produced. But if we just said, and there's a range of like less than a pound per kilowatt hour to up to almost 3 pounds per kilowatt hour. So of electricity, of CO2 produced when you turn on your light switch. Even, and there are all sorts of ways to factor that cost. But if you were to pick the lowest way of removing carbon, most experts agree, Mr. Chairman, there's my computer asleep again. Come on. I'm sorry, Mr. Chairman. I actually have to put in my, I know you're all asleep too.
That's all right, Mr. Chairman, we're still with you.
All right, buddy.
Okay,
I'm
here we
gonna bring it
go.
home.
Here we go.
So, the lowest cost way this is costing us like $200 a ton to remove electricity. That might sound pretty good when you compare it to carbon capture and sequestration of $400 a ton, but it sounds pretty bad when you look at reforestation and other methods like biochar or enhancing agriculture that come in at less than $100 a ton. But we don't have to spend $200 a ton for this, Mr. Chairman. There are other ways to do it, including utility scale solar, which is many times more efficient. But here's the trouble, Mr. Chairman. These people have built these systems. We passed this law a long, long time ago, and we did it, I don't know, maybe thinking it was a novelty. Because here's one thing, Mr. Chairman, we have not done in Wyoming. We have never articulated a carbon portfolio, a renewable portfolio, or we have never put a tax on anything to reduce carbon. The only articulated policy with respect to carbon removal that I know of is buried into this net metering bill that's in our law and works out to be the most expensive way you can imagine. So if the Wyoming legislature wants to stand up and say, let's go to renewables, and let's double down on solar and rooftop solar, fine. But we have never done that. Other states like Oregon, Washington, California, and a bunch more have. We have not done that. But it exists in our net metering law. So, trying to find a fair way to unwind this, Mr. Chairman, the fair way that I've come up with is to grandfather everybody that's out there for as long as they own their systems. They can own them for 30 years and they'll get the net metering exchange. That's what this bill does. But for new systems that come in after the 1st of 2026, January 1st, 2026 or beyond, they will be at rates set by the commission. And all we're saying is that those rates have to be just and reasonable. And that's what the bill does. Happy to talk about details. The bill covers cooperatives, and it covers all these systems that are net metering systems that include some wind production as well as solar, Mr. Chairman, and they're less than 25 kilowatt capacity. I'll do my best to answer any questions, but this is a way for us to take everybody that you've heard from that's enjoying this situation and have them be unaffected by it for as long as they own their system. And there's just one final point I'd like to make before I sit down, Mr. Chairman. You know, this is kind of a regressive system, Mr. Chairman, because the people that will enjoy the most benefits from having rooftop solar are higher electricity users, because they can offset more of their costs with their production. Those tend to be bigger houses, Mr. Chairman. They cost a lot of money for those systems, so they tend to be higher income individuals. And more power to them. I believe in free enterprise and full on. But that is kind of regressive within the universe of utility rate customers, Mr. Chairman. So the people least likely that can make a net metering system work don't use a lot of electricity. Maybe don't own their property and tend to be lower income. So this is a tremendous regressive program that forces poor people to pay for systems enjoyed by richer people. I hope you'll support me in passing this bill forward.
Senate File 111, Senator Scott.
Mr. Chairman, argument is that we have a crisis in CO2 causing global warming. Mr. Chairman, I will dissent from that argument. I will say I know that there is global warming, Mr. Chairman, because I benefit from it. Since I've been in the ranching business, I've gone from being unable to get a third alfalfa cutting to having the extra 2 weeks of growing season that it takes to get that third cutting. And I credit global warming for that, and I think the evidence supports it. Now, having said that, Mr. Chairman, dissenting from the opinion on the bill so far, I rise to support the bill as one who does not necessarily think global warming is a crisis. And I can see how you think global warming might be a problem if you lived at sea level. People living at sea level are not represented in this room. The situation with this net metering system is that the people who use it, Mr. Chairman, do need the fixed costs of the grid because they need power delivered to them when their system isn't producing the power. If they could be completely off the grid, they would be, and they wouldn't have to pay the cost of the grid. But they use the grid, and so what they're doing is they're passing 3/4 of their cost for that off the grid to their neighbors, and that ain't fair. And this bill will correct that. So whether you agree it's a crisis or not on the global warming, this bill's a good idea because the system we've got with what's going on right now isn't fair to the people who don't have or can't afford a rooftop solar system. So, Mr. Chairman, on for the bill.
Thank you, Senator Scott. Senator Cole.
Thank you, Mr. Chairman. I'd like to touch on a few points, and I don't think I want to take a half an hour to do it, but I appreciated everything that was said by the bringer of the bill. Just to talk about this in a more broad sense is that, about CO2. No, it's not good for CO2. Look at the cradle to grave cost to make solar panels. What it takes to make them. I mean, everything goes into it. We tend to want to always focus on the output. Oh, look how clean they are. Well, they didn't come that way out of the earth. They were mined, they were developed, they had people, a lot of CO2 activities go into it. So I don't buy for 1 second they're helping the CO2 situation at all, even if you thought it was bad. The biggest negative is there are parasitic costs to all the other ratepayers. I pay for the infrastructure that delivers the power lines to their house. I pay for everything that they're getting in benefit. I can't blame them. I mean, I guess if the shoe was on the other foot and I was getting something that I shouldn't get, I'd like to take it too, I suppose. But fact is, all those lines, all the linemen, all the stuff that takes to bring electricity, the transformers, everything, the whole system is covered by the rest of the ratepayers, not the people that get the cost like, they're the power company. So I think inherently that's unfair. It's unfair for the people that don't have it. It's unfair for the whole system because they're not paying for the part of the system that makes it happen. I will tell you that they're terribly a burden to the large thermal systems. Big Jim Bridger power plant, whether you agree with that or not, they're a burden to the system. When those systems come up, they turn those systems down. I assure you, those thermal plants are designed to operate at a very high level of output. And when you can't just throttle them up and down like you throttle on your car, it doesn't work that way. They, in fact, have a negative effect on the ability of efficiency of the thermal plants. And there's more, so they're parasitic in a lot of ways. They don't work right now. They don't work at night. There's a lot of issues with sun because it only works when the sun shines. Now, another fact that no one talks about is their intolerance for frequency deviation, which means simply that the system runs on 60 hertz. We probably all heard that before. And why did Texas go to, heck in a handcart? Well, it's because the systems are intolerant of frequency deviation. Simply put, the system has to operate at 60 hertz. It cannot tolerate something less than that or more than that. There's a reason for that, but it has to be there. And the systems that they use to drive that convert the DC to AC cannot handle any frequency intolerance. So the systems drop offline. So you think, oh, this is a great thing. We could, our thermal plants, we can turn them down. They lack the ability to handle a deviation and load because there's no mass to the thing that's generating it like a big generator has, which inherently has the ability to handle deviation. These can't do that. They're frankly, they cost us a lot of money. The federal government thinks they're the greatest thing since sliced bread. They do not deliver on their promise. They do deliver on a benefit to the people that have them at the cost of everyone else that's on the line that's paying for all these other costs to have them be there to get their electricity basically covered that they generate at the cost of that you pay as a ratepayer is what I pay. So I think all in all, it doesn't work. And I think as we get more educated about this and find out just how the system does work, you'll realize they don't work. If you want to charge up your iPhone, boy, they work great. You want to smelt iron? Forget it. You want to make aluminum? Forget it. They're incapable of that. So I'm on and for this for the reasons I've stated, but more importantly, I don't blame folks for taking the deal because it's a hell of a deal. It's a hell of a deal when I can get all the benefits and not pay for it. I just think it's inherently not fair to the rest of the ratepayers, and it's not fair to the system. On and for the bill. Thank you, Mr. Chair.
Thank you, Senator. Anything else on Senate File 111? Anything else? All those in favor of Senator Case's motion that when the Committee of the Whole rises to report it, do so with a due pass recommendation on Senate File 111, please say aye. Any opposed, no. Senate File 111 has passed Committee of the Whole. The next Senate file for our consideration is Senate File 165. Would the reading clerk please read the Senate file?
Senate File 165, cancellation of registration notice amendments, an act relating to elections, sponsored by Senator Pearson. Was referred to Committee Number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Landon, and Steinmetz. Excused, Senator Dockstader. Senator Case, Chairman.
You've heard the reading of the Senate file. What is your pleasure, Senator Case?
Mr. Chairman, I move that when the Committee of the Whole rises to report that it do so with a due pass recommendation on Senate File 165, cancellation of registration notice amendments, and for an explanation of the bill, I'd ask you call on the good Senator Pearson.
Senator Pearson.
Woo-hoo! First time. Thank you, Mr. Chairman. Okay, we're gonna see if I can do this right. I move introduction of SF 165 and ask for your favorable consideration. So, my beautiful senators, this actually was or is a bill that would kind of change the statute. This was something that our county clerks requested. And it's just changing the statute a little bit, that's adding in that in addition to mailing a notice of the intent to cancel registration, that the county clerks can also email the elector. So that's all it is. They will still be mailing the intent to cancel registration, but this just allows them the ability to email as well. Is there?
Very good,
Is that
Senator.
what I say?
Thank you.
How was
Anything
that?
else? Okay. Anyone else on Senate File 165? You don't want to grill the new senator.
Please don't grill me.
All those in favor of Senator Case's motion that when the Committee of the Whole rises to report it, do so with a due pass recommendation on Senate File 165, please say aye. Aye. Any opposed, no. Senate File 165 has passed Committee of the Whole. The next Senate file for our consideration is Senate File 143. Would the reading clerk please read the Senate file?
Senate File 143, Public Monies, Deposits in Credit Unions, an act relating to public funds, sponsored by Senator Nethercott. Was referred to Committee Number 9, which returned to committee recommendation that it do pass. Ayes, Senators Cooper, Jones, Nethercott, and Rothfuss. No, Senator Anderson. Senator Anderson.
You've heard the reading of the Senate file. What is your pleasure, Senator Anderson?
Mr. Chairman, I move that when the Committee of the Whole rise to report, they do so with a recommendation that Senate File 143 do pass. There are no amendments. I will turn the bill over to the able senator from Cheyenne, Senator Nethercott.
Senator Nethercutt.
Thank you, Mr. Chairman. Good senators, you have a bill you have seen before, public monies, deposits, and credit unions. The bill is simple, its concept is simple. It simply authorizes the credit unions of our state to receive and take public funds. That's it. So the bill's length has to do with all of the sections in statute that authorize the financial institutions of our state to receive public funds. Where banks are listed, the addition of "or credit unions" is added, and that's the bill. So why does this bill keep coming before the Wyoming legislature for help? You've heard the saga for the town of Shoshone, which does not have a financial, it has a credit union within its municipality, it does not have a bank. Requiring that community to drive into the city of Riverton to make its deposits daily. For those of you that are familiar with the town of Shoshone, it actually does receive a high number of cash deposits due to those coming through town with a lead foot. And so if you're paying a speeding ticket or any other type of traffic citation, they are receiving those funds typically in cash or other types of deposits that a municipal entity needs to manage. The town hall has moved, but for the beginning of time, it was right across the street from the local county credit union. And they were prohibited from walking those cash funds across the street and safely depositing them into the safe and into those accounts in interest-bearing revenue. Instead, they were required to have an employee, of which the town doesn't have many, accompanied perhaps by a law enforcement officer, because everyone knows there's significant cash to be apprehended, to drive it into Riverton on a regular basis in order to be deposited. That is a fundamental challenge to the operation of one of our cities, towns, and counties. Knowing you've heard that argument before, and it wasn't quite enough to get it across the finish line, here's some other examples. The Albany County Junior Livestock Auction, of whom a major credit union there provides staff services and helps facilitate the entire auction through their volunteer and community services, and they cannot deposit those funds. Instead, they hold those funds from the junior livestock auction, and so then the credit union takes it into a bank in order for this. So they store it in their safe as they receive those funds, and then because they're prohibited from making a deposit, they have to take it to the local bank. So I hope the banks don't feel like their territory is being impended on by the desire of the Albany County Junior Livestock Auction children and their efforts, I know, but that's the kind of challenge that is presented. Then we have the local education credit union here is unable to accept deposits from the PTO due to public fund classification under the school district's EIN. So the PTO is able to have a bank account through the school district's EIN. The local education credit union, of whom is closely associated with that PTO, they can't accept those deposits. And in the heart of the state, where I'm originally from, an ag producer's credit union could not administer state farm loan funds for an irrigation project due to a restriction on those state funds. And what really, I think, was pretty harmful to a community was a major credit union could also not participate in loan funds for an assisted living facility project because it helped facilitate state public funds. The credit unions in Wyoming, of which there are 23, they have 69 branches, and they serve over 330,000 members. It's a good chunk of our population here in Wyoming. The arguments about the unfairness of the situation are not new for us. We understand that banks are regulated at a federal level, and the banking industry feels like that's unfair. I appreciate that, but that doesn't mean that Wyoming taxpayers and Wyoming constituents shouldn't be able to avail themselves of credit unions because of the federal regulatory law on banks. The same consumer protection principles on banks applies to credit unions. So similar to FDIC, they have the credit union insurance fund, which is up to the same amount of $250,000 So any of those consumer protection concerns do not exist. The money is as safe as a credit union as it is in a bank. What we do know, and I think what is most concerning and maybe most compelling now, or at least what I find compelling, is the debanking of our legacy industries in Wyoming. This effort is not being done by your local Wyoming banks. I want to make sure when I have this discussion, I am not talking about Wyoming chartered state banks. They are not participating in the debanking of our legacy industries in Wyoming. However, all of the national banks, most of them are. And what does that mean? They have ESG-related policies. They have policies that don't support political parties. They have policies that don't support oil, gas, coal. They have policies that don't support our firearms industries. And yet, our Wyoming public deposits are being placed in many of those institutions, but our local credit unions cannot. And so the inconsistency and policy positions between our banking industry and our local credit unions, I think, has reached really pretty parallel times, or pretty polarizing times, making the prohibition on the ability of them to accept and facilitate public funds just unacceptable and not the right policy for Wyoming. And so, good senators, I bring this to you for another year, seeking your support, recognizing that it is time to level this playing field and allow public deposits in our credit unions that are working tirelessly to serve the people of Wyoming.
We are considering Senate File 143. Senator Anderson.
Mr. Chairman, Senate File 143, I just wanted to bring to your attention, we had the mayor of Shoshone on the on the Zoom, and we requested that he work on establishing a malt shop again in Shoshone. And he allowed us how if this passed, he would really work on it. So I don't want to influence your vote or anything, but you might be able to get a malt shop out of this.
Oh, there we go. Well, let's go to Senator Crum and then to Senator Scott.
Thank you, Mr. Chairman. You know, as a 43-year Wyoming banker, I got to tell you, there's a place for credit unions in America and in Wyoming. They were designed. A credit union that I was very familiar with growing up as a kid was the Parco Federal Credit Union. What is Parco? Parco is the town of Sinclair. They changed their name. That credit union was designed to serve a common bond to people, the people that worked at the refinery, to help them buy houses and deposit money on night shifts and different things like that. There's a place for that credit union in America. Credit unions today are not that. They look a lot like banks. Even more so than banks, they build big buildings because of tax advantage situations where they don't pay state income tax or sales tax. They do pay property taxes. Credit unions, you would think there's a war between banks and credit unions. There's not. Banks and credit unions want the best for our communities, to help build up our communities and work together to do that. But when you look at what this bill does, it says deposit money, public money in a credit union. I agree with there's a handout out here somewhere that went around that said, credit unions, your money is not a deposit. You're owned, it says, by the shareholders, which are, they say the word depositor. It's not a deposit. You purchase a share in the credit union. It becomes an investment. It's not a deposit, it is an investment in the credit union. And you hear around, well, I get this really good rate of return on my deposit, which really is an investment, but when you purchase an investment in a company, which you are in a credit union, it says you even get a right to vote on the credit union because you do have a share in the credit union. These are not deposits, but with that return, you're getting 0 point nothing to say 2%. Well, an investment you should get anywhere to a minimum of 6 to 15% at least return on your stock that you buy on year in and year out basis. So it's not a significant return on your investment. The Wyoming Constitution, you know, in Article 15, Section 7, says the money must be deposited in banks. And then it goes on to say it prefers if it was a Wyoming bank. If we want to change this law and allow investments in credit unions, I suggest that it's a constitutional amendment to our Constitution that allows this to happen. We talk about the town of Shoshone not being able to get their funds, and I feel for the plight. We all get to choose where we live. They do only have a credit union, but the banks, other banks in Fremont County have said they would come out free of charge to pick up those deposits and shuttle them for free for them. We talk about the Albany County, about a credit union in Albany County that does the 4-H sale. Many banks have offered to do it. The credit union is underbid the banks on doing the depositing function. It's not that there's a lack of banking to do the deposits in Albany County. It's a credit union that may be underpriced or overcommitted on what it can really do for the fairgrounds there. You know, talk about FDIC and NCUA. What do those initials stand for? FDIC is Federal Deposit Insurance Corporation. What is it? It's an insurance company to insure your deposits. And what do they do like any insurance company? They manage their risk. They manage their banks. The NCUA, what's it stand for? National Credit Union Association. What was its primary purpose when it was started? A marketing firm. That's what it was. Now it has an insurance fund in it, but you decide, an insurance company, a marketing firm. You make your decision, I'll let you do that. Also under our statutes in section 94715, it talks about when you make an investment, because that's what these are investments. They're not deposits, you're buying shares, that we're supposed to get the highest rate of return possible when we buy our shares and the risk. I ask you, is 0.nothing to maybe 2% the best we can do on that money for public entities, or is there other investments? These are not deposits. It's purchasing a share, which the credit unions clearly state that that's what you're doing. You're purchasing shares in an organization. You have a right to vote those shares. So with that, I'm not opposed to credit unions taking money, but currently under our statutes and our Constitution, they're not allowed to do it because they are not deposits, they're investments. And so I ask you to vote no on this bill, and if we need to, let's support a constitutional amendment to allow credit unions, the cities to invest in credit unions. Thank you, Mr. Chairman.
Thank you, Senator Crum. Let's go to Senator Scott and then over to Senator Ide.
Mr. Chairman, following on that, I think the argument is very clear that credit unions are providing all the safety and all the functions, basically, that a bank can provide, and that we ought to allow them to be depositories. But we encountered this issue several times when I was in Committee 7, and we were never smart enough lawyers to figure out how do you get around the specifics of Article 5, Section 7, which says that the funds should be deposited in a national bank or banks, or in banks or banks incorporated under the laws of the state. It's pretty explicit. Now, we have a bill brought to us. It's obviously been worked over by extremely intelligent attorneys, Mr. Chairman, and I'm interested to find out how do we get around that provision of the Constitution, because we were unable to do it.
Senator Ide next, and then we'll go to Senator Nethercott.
Yeah, thank you, Mr. Chairman. lot of good discussion, good new senator here from Albany County. And I just want to give my thoughts on this. You know, the bringer of the bill, you know, obviously this adds options for, you know, deposits in other institutions in the financial world. And hopefully those benefits translate into good results for the taxpayers. I like more competition. I think it's good. You know, the opponents of this will argue that you know, they're less regulated. And back to our discussion on a bill earlier, this is good. Maybe the banks can move toward more, you know, less regulation to get competitive with credit unions. So, you know, I'll just keep it short there. Less regulation is good. I think this credit unions accomplish that task. I think it's up to the customer to vet who they're depositing their money with, or the state or local governments. And that's for them to decide whether they want a share of the company or they want to deposit in a bank. So thank you, Mr. Chairman.
Thank you, Senator. Senator Dockstader.
Thank you, Mr. Chairman. If we're going to do that, we ought to equal a playing field. Change things around a little bit for the banks so they're not so much under regulation. Right now, we're giving the credit unions, letting them have tax-exempt status. Maybe this is maybe about a 20% subsidy for them to step in and take care of this. We've already had the Constitution quoted. That's been adequately covered, Article 15 and 7. But this whole concept of allowing them into a world where others have to deal with real life situations, where we're taking the credit unions, giving them a pass, field pass, to essentially get a break while the banks still have to have their standards. Why do we do that? It's like, if you're in a football game, you might as well move the goalposts, help with, maybe put some scores up for the other team, the credit unions. I can promise you that football team that came in and saw us this morning, they were on an equal playing field when they went out to play. And they earned that right, just like the banks earned that right. So why do we give this freebie status to the credit unions? It makes no sense. Shoshone to Riverton? I make repetitive 450-mile trips, one-way trips across this state to take care of my business for the state. Believe me, Shoshone to Riverton's easy. Appreciate the offer on the malts. I miss those on my cross-country trips. Try to make up for it with an ice cream cone at Farson. Sorry, I said the real name. But let's not give this freebie to the credit unions. If we're going to do this, put them on an equal playing field. It does not make sense to do this, to move the goalposts, give them a couple touchdowns ahead. This makes no sense whatsoever to give the credit unions this break. Thank you.
Thank you, Senator. I miss those malts also. Further discussion on Senate File 143. Any other discussion? Oh, I'm sorry, Senator Barlow. Take it away.
Thank you, Mr. Chairman. So I've actually been on this bill before, and the district I represent has a small community, has a credit union, and there is some words in this constitutional language that I think haven't been looked at, and it says, "shall, when practicable." If there is not a bank in your community, how practicable is it? And when the mayor of that small community, that's the heart of coal mining in my community, says, hey, when I get my tax check on a Friday afternoon, i.e. a paper check from our department here at the state, and then I've got to sit on that thing for a day or two or whatever, or the weather is bad, or et cetera, that doesn't give him any pause when literally a block and a half away is a federal credit union, Mr. Chairman. Practicable. What works in your community may be different than another. The second thing I would say is when the good majority of Florida spoke about folks that want to engage with the state in different programs, I think it was a farm program loan thing, and they had to go get a different financial institution to have access to those funds. What did they choose to do? They chose to forego that opportunity. Forego the opportunity because they didn't want to go through some more hoops and rings. So when practicable, should mean something in Wyoming. And I believe this constitutional language, where it says, whenever practicable, could be applied in some of these circumstances. Thank you, Mr. Chairman.
Thank you, Senator. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I think it's important to look at the context of when this 15.7 constitutional provision was written and the fact that at the time there were no credit unions. Credit unions came into existence later. The requirement to deposit them in banks and banking institutions where practicable was based on a desire to have strong rules, oversight, and regulation. It wasn't a choice between, well, we want to go down on record saying banks, not credit unions. That was not the philosophy because there were no credit unions. So when you contemplate this, and again, where practicable is an important piece, but as you think it through, I think it's important to realize that at this point in time, a federal credit union, or even a state credit union, but we don't have any of those right now, I don't think we can statutorily, are going to be regulated in the same manner, albeit by different entities, different regulators, but the same level of scrutiny, the same level of insurance, the same level of oversight as a bank. So the constitutional intent is certainly fulfilled, even if they didn't have the capacity to look into a crystal ball and include future names for what a banking institution might incorporate. So it's important, in my opinion, Mr. Chairman, to take that into consideration, that while we, can be very restrictive in reading that provision, the idea, when we think of a bank, we think of a financial institution that lends, that's a depository institution, and that the nuances of the differences are often lost on people. Really, certainly not my good friend from across town. He gets all the differences. And I think those of us in this chamber have talked about them often enough that we get the differences pretty well too. But again, these are financial institutions that are regulated, and when you contemplate the perspective of the framers that drafted this Constitution and what they were interested in, what their interests were, a credit union is going to satisfy that, Mr. Chairman. I think it's consistent.
Thank you, Senator. Senator Crum.
Thank you. To my good senator from crosstown and my other great senator from north, just a couple comments. I do agree with the language that was in there. It said we're practical, but it mentions banks. It doesn't mention credit unions, and my good senator from across town too, I would agree that it doesn't mention credit unions. And that's why I bring up, if we want to add credit unions, it should be in the Constitution. It's not for us, 31 people in this room, to decide what the Constitution should say. It's what it does say. And it doesn't mention credit unions, it mentions practicable, but it mentions it in the terms of banks. It doesn't mention it in the terms of my neighbor Joe next door or the hardware store that, did the trading in money. It said banks when this thing was written. And if we want to change it, it's a constitutional amendment that should be put up. And it's not for 31 people to decide that we're going to take deposit and now allow investments in banks. So with that, again, I'm still a no on this.
Thank you, Senator. Senator Nethercott.
Thank you, Mr. Chairman. A couple of issues to address. There was the issue on taxes. It's important to recognize that banks are structured differently based on the bank. There's a concept of a subchapter S bank, which is how its election is with the IRS. They pass along earnings onto their shareholders who ultimately pay taxes, but are also exempt from federal corporate income tax. There are 16 of these subchapter S banks in Wyoming. So 16 of those do the exact same concept where they pay no corporate tax because they pass those on that are allowed to receive public funds. So any argument concerning that component is misplaced. The Constitution. I would hope that this body would recognize that I would not be presenting before you a bill that would be so unconstitutional. As a result of this bill coming before this body for such an extended period of time, this issue has been fully vetted by numerous attorney generals and your LSO. One, it's important to recognize what the good senator from the Ivory Tower indicated. Credit unions didn't exist at the time of the adoption of the United States or the Wyoming Constitution. Credit unions coming into existence in, I believe, 1934. Since that time, there have been no issues with credit unions, and they've been around long enough to provide the type of security I think that we're all seeking. That said, when we address this constitutional prohibition that is alleged, which is a good question, it's important to understand how the Wyoming Supreme Court would interpret this law if it were to pass under a constitutional challenge. And so the Wyoming Supreme Court, comfort to all of us, presumes that a statute is constitutional, and any doubt concerning that statute is to be resolved in favor of the statute's constitutionality. So it's already viewed through the lens of being constitutional as a result of the Supreme Court's statutory construction rules. In addition, constitutional provisions are to be broadly and liberally construed with a view to upholding acts of the legislature, if in doing so the purpose of the constitutional provision is achieved. Those are the words of your Wyoming Supreme Court. The language of the Constitution and the language of a statute are construed similarly. I think that's important. The Wyoming Supreme Court has stated, quote, "The language of a constitution is not to be limited to the precise things considered therein, but it embraces other things as they come into being of the same general nature or class." That's a Wyoming Supreme Court case from 1957 that acknowledges that things exist today that didn't exist at the time the Constitution was enacted, and that there are statutory construction principles that apply in making this analysis. And so long as those purposes serve, those distinctions serve the same purpose, it's considered lawful. And so when we compare banks and credit unions, there are similarities and there are differences, but fundamentally that similarity and those concerns of the constitutional are met. Those consumer protection concerns are statutorily and constitutionally met. And our Attorney General for years and years, for at least 20 years, this is the oldest opinion I have and has continued throughout, that because federal credit unions and state credit unions perform the same fundamental functions as a bank, it is arguable that allowing deposits of public funds in credit unions does not violate the spirit or intent of the Constitution. So this issue has been reviewed to exhaustion by our Attorney General throughout the decades, by our LSO staff, and this is ultimately the conclusion when you review that constitutional provision in combination with the Wyoming Supreme Court's statutory construction rules, and when we do an analysis of the fundamental purposes of credit unions and banks, and that in this application, they serve the same fundamental purpose. Therefore, the bill is constitutional. Thank you, Mr. Chairman.
Are you ready for the question? Let's go to Senator Dockstader. We'll keep this going a little bit longer, and then we'll come to Senator Scott. Wrap it up. Okay.
Thank you, Mr. Chairman. Not talking necessarily about the Constitution. We can see that on both sides as you go through here. I'm talking about an unequal playing field. I know a little bit about that. Every morning, we go on the airwaves, and our biggest competitor is government-funded radio. We have to deal in an unequal playing field, and that's what we're doing here. We're creating an unequal playing field. We're handing a freebie to the credit unions and saying, here you go. We're going to give you a boost and open up the door for you. We're going to have these folks over here play by the rules, and you get a freebie to step in and use the system. Adamantly opposed to this bill. Thank you.
Senator Scott.
Mr. Chairman, I asked earlier about the constitutional ability here. And I will say, I think I now discern the general principle that's involved. appreciate the debate. And I will say there's a precedent for what we've heard and for the principle. And, Mr. Chairman, I'm going to have to use a few proper names, but they're on a precedent that's over 100 years old, so it's not indulging in any personalities. So it's well within our rules. Mr. President, the principle was uttered by a distinguished politician, knew something about the Constitution, Mr. George Washington Plunkett of Tammany Hall, and recorded in a delightful book called Plunkett of Tammany Hall, written by a New York newspaperman of that era. And he interviewed Mr. Plunkett on a number of things, and there's all kinds of good advice in there, graft and honest graft and all that sort of thing. But on the constitutional issues, he said, what about it? Some of the things you do, say, against the Constitution. And the principle, Mr. Chairman, is what, as Mr. Plunkett articulated it, is what is the Constitution among friends. And I think that's the principle that's being applied here, Mr. Chairman, and it has a long history.
All those in favor of Senator Anderson's motion that when the Committee of the Whole rises to report it, do so with a due pass recommendation on Senate File 143, please say aye. Aye. Any opposed? No. No. The chair is in doubt. Would those in favor of Senate File 143 please stand? Senate File 143 has passed Committee of the Whole. We have 21 in favor of the bill. The next Senate file for our consideration is Senate File 186. Would the reading clerk please read the Senate file?
Senate File 186, Advanced Nuclear Reactor Manufacturers Fuel Storage, an act relating to environmental quality, sponsored by Senator Cooper. It was referred to Committee Number 9, which returned a committee recommendation that it do pass amended. Ayes Senators Anderson, Cooper, Jones, Nethercott, and Rothfuss. Senator Anderson, Chairman.
You've heard that reading of the Senate file. Senator Anderson, what's your pleasure?
Mr. Chairman, I move that when the Committee of the Whole rise to report it, do so with the recommendation that Senate File 186 do pass, and there is a standing committee amendment. Could we have that read in right now?
Senate File 186, Standing Committee Amendment Number 1, pages 2, lines 11 through 16.
Thank you. And to explain this bill is Senator Cooper, please.
Senator Coop.
Thank you, Mr. Chairman. This is a bill that's massive as far as the state of Wyoming goes. This is a Jobs and Economic Development Bill for new industry coming out in Wyoming. I'm going to kind of dwell on about 3 or 4 points here before we go through the bill. By economic development and jobs, we've got 2 microreactor manufacturing companies looking at Wyoming very closely right now. Close enough that they're nearly ready to announce, I think. They've selected some sites and they're ready to move forward with their permitting in the next short period of time. So we have an opportunity to help these 2 companies come to Wyoming. And I think as legislators, we have a responsibility to help them come to Wyoming. What this bill does, it brings our current nuclear language into conformity with the NRC language. to ensure that we don't lose our primacy over the NRC nuclear regulatory issues. So, jobs-wise, what we're talking about on each one of these two facilities is probably about 250 direct jobs, really good jobs, 80 to 100,000 a year type salaries. Plus the ancillary work that goes with it. We'll need trucking companies, we'll need security companies, we'll need supply companies, manufacturers for parts, and so there's just a huge amount of development to be done with this. There's been some questions about the environmental issues of it. We need to keep in mind that what we're wanting to do with this bill is ensure that that this manufacturer, what they're gonna do is they're gonna manufacture these micro reactors in Wyoming, and they'll fuel them in Wyoming. And then these reactors will be distributed out across the world to maybe remote villages or islands somewhere that are off-grid, or maybe a mine up in the far north, somewhere like that. To replace diesel generators is primarily what their goal is. That reactor will stay out there 4 or 5 years, and then it'll come back to Wyoming. A new reactor would be sent out, and that reactor would be refurbished and refueled in Wyoming. In order to refuel it here, that spent fuel has to be stored on site. The NRC requires that. We don't get a choice in that. That's where it has to be stored. So the language that we're doing here is to make sure that our language matches that NRC language. Now, the volumes we're talking about are very small. A few pounds of nuclear reactor or nuclear material, because these are very small reactors. These are like 1 megawatt. So very small reactors. They fit in a shipping container, put them on a truck, ship them out, put them in an airplane, take them up north somewhere. Pretty cool technology when you get right down to it. Now, some things that we need to consider here is what we're talking about again is spent fuel. We're not talking about nuclear waste. We're not making this a big nuclear waste dump. We're talking about the spent fuel for these specific reactors for that manufacturer only. This manufacturer has to maintain ownership of this material from cradle to grave. When they receive the material, put it in the reactor, ship it out, bring it back, and store it. They're responsible for that fuel the entire time. So we need to keep that in mind. As far as how long it stays here, that's still in the air, all right? And we're gonna be real straight up about that. The United States hasn't addressed the spent fuel storage as well as they could have, not like the rest of the world. In December, I had the opportunity to go to France and tour their nuclear reprocessing center. They have almost as many nuclear reactors as we do. They power most of France with nuclear power. They bring all their fuel into one site in big rail-sized casks. They reprocess it there. They extract the spent fuel, reprocess that fuel, and put it back into the fuel stream. So they end up with a very small amount of waste. From a rail-sized cask, they end up with 2 small casks, one about like this, 3 foot by 5 foot, that has the high-level radioactive material in it. The second cask has all the stainless material from the rods. They store that in a facility right there. They've got 50 years of fuel storage, of their waste storage, in 2 rooms about the size of this room. 50 years worth. They've been doing this since 1975. We can't seem to get past the politics of it. But we're not talking about, at this time yet, about reprocessing. There are several states in the United States right now that are looking at reprocessing. So what we're talking about today is spent fuel storage. Now, on that trip also, I got acquainted with several people from some states to the east, far east even, far east in the country here, that are considering spent fuel interim storage. So these sites are coming together, and probably in the next few years, there will be some spent storage facilities in the United States. Right now, all of the NRC requires all of the spent fuel to be stored on site for whatever facility it is. Our Natrium facility, that fuel will be stored on site. We passed a bill a couple years ago that very similar to this that allowed that. So back to the bill. Again, it has a few pages of definitions. It has several pages of what's required for the application for the DEQ. And then it's got some conforming language going through it. And it's got a really nice amendment that was put together in cooperation with the stakeholders involved. That is the manufacturing company and a couple of different environmental groups were involved in this amendment. And with that, I'd like to have the senator from Niagara Tower present that amendment.
Thank you, Senator Cooper. And Senator Rothfuss, that was a reference to Standing Committee Amendment number 1 to Senate File 186. That has been read in.
Has it been moved, do you recall?
It was not moved.
Let's do it. Thank you, Mr. Chairman. I move Standing Committee Amendment number 1 to Senate File 186. Ask the body's favorable consideration. This was a combination of a few different amendments that were brought with a few different purposes. One was stakeholder input on what is and isn't necessary. A second provision is a concept of previous legislation that was more generalized for holding nuclear material wasn't relevant, so we struck a number of paragraphs that aren't relevant for this particular piece of legislation. And then the third concept, Mr. Chairman, is the idea that the NRC regulates most of this anyway. And so if we're complying with NRC in certain areas, we're going to be deeming that as sufficient for Wyoming's storage of spent nuclear waste. So to go through the amendment specifically, on page 2, we delete Romanet 2, the dry cask storage definition. We're not going to need that. On the bottom, Romanet 4, spent nuclear fuel, we add a little bit of language that allows us to take away a further definition later. So after amended, it says, and includes other high-level radioactive waste associated with the manufacturing and refurbishing process. This is very specific to these advanced nuclear reactor type that is going to have the refurbishment and the reprocessing, excuse me, of the materials. What we see with regard to page 3 is largely just conforming language, tweaking some language, adding person instead of applicant, which is more consistent with statute. No changes on page 4. On page 5, we delete, just for wordsmithing effectively, about half of paragraph C, the lines 3 through 6, and change it to the department through the director shall verify the following. And again, we swap out applicant for person. We delete Romanets 2 and Romanets 3, which relate specifically to the storage type and how the storage terms will be, and insert new language that you see at the bottom of the amendment. The Romanet 2, which is newly inserted, excuse me, indicates that the installation only stores spent nuclear fuel from the advanced nuclear reactors or other high-level radioactive waste associated with the manufacturing and refurbishing process on the site of the advanced nuclear reactor manufacturing facility after first meeting all requirements of the United States Nuclear Regulatory Commission. That's mirror language to what we have in Article 21 of the same title. So it's just conforming the language, and it's a lot more concise than what is in the bill. On page 6, we strike the paragraph D related to industrial siting and insert an alternative, which basically indicates that industrial siting would be available, but only to the extent that it doesn't contradict or create duplicate endeavors to the NRC regulation. And that's how we did it also in Title 21. We delete the F paragraph. It was unnecessary to this bill. On this page 7, we delete the H paragraph, also unnecessary to this bill. It's not relevant. Going to page 9. We no longer need this definition in prior statute of high-level radioactive waste because we accounted for that before, so we delete the Romanet 1, or the new language in Romanet 1, I should say. Bottom of page 9, we delete the new language. And then on page 10, you can see that the last amendment is after fuel on line 2, insert or other high-level radioactive waste associated with the manufacturing and refurbishing process. So this better conforms to our existing statute and narrows the scope to what is appropriate and applicable, as well as defers to the NRC, as we've done in all our prior legislation, where if the NRC is governing it, we make sure that that's what is dictating the policy, rather than being overly prescriptive in statute, Mr. Chairman. That's the amendment. Happy to answer your questions on the standing committee amendment. Otherwise, I'd call for the question.
Thank you, Senator. Well done on the amendment. Any discussion on Standing Committee Amendment number 1 to Senate File 186? All those in favor of Senator Rothfuss's motion to adopt Standing Committee Amendment number 1 to Senate File 186, please say aye. Aye. Any opposed, no? The Standing Committee Amendment has passed. We're back to you, Senator Cooper, to take us home on this bill.
Thank you, Mr. Chairman. So real quickly again, to summarize what the bill does and doesn't do. It's a jobs and economic development bill. It brings literally hundreds of jobs to Wyoming at a time when we're struggling with some of our energy, other energy sources, and it's going to bring jobs to those communities. It retains our primacy. Some of the naysayers out there have said it's not needed because the NRC is going to do this anyway. It is needed because it retains our primacy with the NRC. That's a huge thing for the continued growth of nuclear industry in Wyoming. It's been environmentally vetted by the DEQ and by bringing those environmental groups in and set them down with the manufacturer. They had participation in the amendment, and it ensures cradle to grave ownership of this material. We're not going to be a dump for some other state. We're not going to be allowing other countries to bring their nuclear fuel, spent nuclear fuel into Wyoming. This is for Wyoming manufactured equipment being deployed wherever it's being deployed around the world. When it comes back in here, the material comes back with that reactor and is stored back on the site of the manufacturer. That's the only material that can be there. With that, stand for questions.
Thank you, Senator. Senator Cole.
Yeah, thank you, Mr. Chairman. Just to, more insight on what the rules would allow, near, a large community. I mean, just what are the rules? Does anyone have any idea where it would be sited, or would it be anywhere in town? I don't know. I think there's a lot, the constituents have a lot of questions about where would this go. I'm in favor of the bill, just want to say that on and for the bill, but I'd like to have some information about just what, if any, what are the details? Thank you, Mr. Chairman.
Any other questions on 186? Senator Hutchings?
Thank you, Mr. Chairman. For a novice looking at this bill, and you're seeing a lot of words like waste and spent, and there are some concerns in the communities around Wyoming that this will be a lot of waste coming to our state, even though he's saying it's not. And then when we did the amendment, there were a lot of words thrown out like, we don't need this, we don't need that. I'd like to know how the bringer of the bill feels about all that was pulled out of the bill. Thank you.
Okay, let's go to Senator Smith, and then we'll come back to the sponsor.
Mr. Chairman, I got a question for the sponsor of the bill. What's the difference between nuclear waste and spent fuel? I think that it was said there is a difference. And so is spent fuel not nuclear waste? That would be helpful to know. And so that's just something I got rolling around in my mind about this bill. Thank you.
Okay, let's first, Senator Cooper, I'm going to go to Senator Dockstader for one more, and then we'll come back to you. So, Senator Dockstader.
Thank you, Mr. Chairman. One more note for good Senator Cooper's notepad. As I recall some of the meetings I was in, could you give us the estimated job count and the estimated income revenue for Wyoming?
Did you hear that one okay, Senator Cooper? Senator Dockster, I had trouble hearing you as
Thank you.
well.
Estimated job count, estimated income for Wyoming as a result of this.
Thank you, Senator. Appreciate that. Senator Cooper, do you want to take a couple of these and while everybody gets their guns loaded again? And
The estimated job count, what we're getting from the manufacturers is about 250 direct jobs per facility, plus ancillary jobs. So we're talking somewhere between 500 and 700 jobs, high-paying jobs, 80 to 100,000 a year, probably 80,000, 70, 80,000 for a starting wage. So we're looking at, for payrolls, somewhere in the $25 to $30 million range per facility. That's a pretty big deal. That creates a lot of revenue for the state. The facilities themselves are quite large, so they're going to generate a lot of property tax, if you will, in these different areas. One of them, it's my understanding, it's upwards of a million square feet of space under a roof. So big facilities. These are big operations. Think about some of the other questions. The siting, this will all be done through the Industrial Siting Commission. So they have some sites picked out. They've got to be approved. Things such as population and whatnot will be considered. Keep in mind that around the country, in the 70-plus places where the spent nuclear fuel is kept today, probably 95% of those are in high-density population areas, mostly on the East Coast. In fact, those of anybody in here that's been to MIT to their fuel, to their nuclear symposiums, one of the tours they gave us is a tour of a nuclear facility downtown Cambridge, Massachusetts. That fuel has to be stored right there, right downtown Cambridge, right downtown Boston. So this is not something new. This is something that's been done forever. The difference between spent fuel and nuclear waste. I talked about that rail-sized cask coming in. At least 96% of the spent fuel is recyclable. That other 4% is some high-level material that's vitrified and turned into a glass and stored in one of those casks, those small casks I was talking about. The rest of that spent fuel or waste that is developed when they do reprocess is the stainless material, the actual steel rods themselves. They slice them up in little bitty pieces, put them in these same casks, compress them very tightly. So from a rail car size unit of spent fuel, they get 2 small casks of waste. That's the actual waste material that they have to store permanently. And in France, they're doing it right there on site. Finland's building a new repository. Japan's building a new repository. Canada has cited their new repository. And as I said, there's several states in the United States today that are considering the interim temporary fuel storage as we speak. There's some pretty serious money in that, billions of dollars a year to the state, and they are seriously considered in other areas. So I think that caught most of the questions.
Senator, one more. Are you comfortable with the amendment to the bill? I think that was one other question that you had right over here.
I
regarding the
missed that
amendment.
question. Thank you, Mr. Chairman. Yes, I am comfortable with the amendment to that bill, and the reason I am is because we went to the manufacturer and set them down in the same room with a couple of representatives from different environmental groups, and they worked that amendment out together between the manufacturer and environmental groups. This wasn't our amendment, this was theirs. They said, this makes this a better bill on both sides of that, of the spectrum here. So it was a joint effort to build this amendment.
Okay, thank you, Senator. Hope that helps Senator Hutchings. Senator Anderson.
Mr. Chairman, Senator Cooper did a great job explaining all that. I just want to emphasize one more time that spent fuel can be refurbished and reused. And we talked to this manufacturer whether they would do that and refurb and use those, and they said they would. So the amount of nuclear spent fuel we have on site might be minimized when the United States builds this plant to refurbish spent fuel. We had one of those plants in Connecticut, and a past president unfunded it, and it was torn down. Or we would be doing that right now in the United States. Japan, Germany, France, all of them reuse their spent fuel. And that's what we want to do in the future. Thank you.
Senator Hyde.
Yeah, thank you, Mr. Chairman. Just a quick question. You know, the bill essentially exclusively defers to the federal government, the National the Nuclear Regulatory Commission, the NRC, which looks to me like we're giving them primacy over the entire process of approving this. And that's where I get, you know, all of these bills, we always say state and federal law, and a lot of those laws are not good laws. They're not in pursuance of the Constitution. So I'm afraid of this just for that reason. We're just giving them exclusive authority here on nuclear waste. Thank you, Mr.
Senator Anderson.
Thank you for that question, Senator. We do not have primacy on this part of the nuclear. We have primacy on nuclear, the tailings that we have at Shirley Basin and Pathfinder but we do not have primacy on this. It is still NRC primacy. We'd like to get that, and as we move through this, we'll work toward getting primacy with this, but that'll take us 5 years to get the primacy for production.
Thank you, Senator Anderson. Senator Cooper.
Thank you, Mr. Chairman. One thing to keep in mind, though, if we don't, and when I was talking about it maintains our primacy, if we don't maintain language that's compliant with the NRC, then we risk losing primacy on our other issues. So that's important. Thank you for pointing that out, Senator Anderson. Yeah.
Thank you, Senator Cooper. Anything else on Senate File 186? All those in favor of Senator Anderson's motion that when the Committee of the Whole rises to report, to do so with a due pass recommendation on Senate File 186, please say aye. Aye. Any opposed, no. Senate File 186 is passed Committee of the Whole. Senator Nethercott.
Mr. Chairman, I move that the Committee of the Whole beg leave to rise and sit again.
Woohoo!
Just going to be a fake out, though, so hold down, Senator. It's going to be a fake out. No, we're going to sit again.
I was
sure?
kind of given.
All right, Mr. Chairman, our chief clerk has corrected me. Mr. Chairman, I move that the Committee of the Whole rise and report, but we will come back into Committee of the Whole to complete that budget, so.
Thank you.
I move that the Committee of the Whole rise and report. We are rising and reporting.
You have heard the motion. All in favor, say aye. Any opposed, no. Okay, you heard the majority leader. We will gavel back in for a second Committee of the Whole in a little while. Mr. President.
Thank you, sir. Good job.
Thank you.
Don't get too comfortable. Committee of the Whole report.
Mr. President, your Committee of the Whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 149, do pass. Senate File 152, do pass amended. Senate File 139, do pass amended. Senate File 101, do pass. Senate File 114, do pass amended. Senate File 148, do pass amended. Senate File 167, do pass. Senate File 127, do pass amended. Senate File 111, do pass. Senate File 165, do pass. Senate File 143, do pass. Senate File 186, do pass amended. Senator Landon, Chairman.
Thank you. Where'd he go? I told him not to get too comfortable. Oh, wait, here he comes.
Mr. President, I move adoption of the Committee of the Whole report.
You've all heard the motion. All in favor, say aye. Aye. Opposed? Committee of the Whole report has been adopted. Madam Majority Floor Leader. Right? Yeah. Back to you.
I got a 50-50 chance here. Mr. President, I move that the Senate resolve itself into Committee of the Whole to consider only the Budget Bill, Senate File 1.
Nailed it. You have heard the motion. All in favor, say aye. All opposed, no. Motion's carried. Senator Landon. Wild Bill. Man, oh man. I need you.
Okay, sorry.
You're all right. There you are.
One section.
The Committee of the Whole will please come to order. The reading clerk will please read the Senate file.
Senate File 1, General Government Appropriations, sponsored by the Joint Appropriations Committee.
Senator Salazar.
Thank you, Mr. Chairman. Mr. Chairman, I move that when the Committee of the Whole rises to report, you do so with recommendation that Senate File 1 do pass. And for the explanation of this bill, Mr. Chairman, I would ask that you call on a member of the Appropriations.
Thank you, Senator. Senator Guru.
Mr. Chairman, I would like at this time to ask that you open section 350.
Go ahead, Senator.
Okay. Thank you, Mr. Chairman. On page, if we can switch gears here and go back to your summary sheet, go to page 16. Look on the bottom line there, and you will see section 350. Or all you do is go to page 83 of the bill itself, and you will see section 350. And it says JAC, your Joint Appropriations Committee added section 350, which limits employee salary increases from general funds and provides a requirement that salary increases from non-general fund sources be approved by the chief executive and provides for a similar process for the judicial branch. This restores section 310, which was previously rejected by the governor. I'll be glad to stand for any questions.
Discussion. We are on 350, section 350. Any discussion? Unless there are further questions, that concludes the explanation of section 350. Senator Gru?
With that, I would move that we close the discussion on Senate File 1.
You've heard the motion. All in favor? Let's do this the right way. Thank you, Madam Clerk. All those in favor of Senator Salazar's motion that when the Committee of the Whole rises to report, that it do so with a favorable recommendation of Senate File 1, please say aye. Aye. Any opposed, no. That motion has passed. Madam Majority Floor Leader.
Mr. Chairman, I move that the Committee of the Whole rise and report.
Woo-hoo. You've heard the motion. All in favor, say aye.
Aye.
Any opposed, no. Now I'll turn it back to the president and try not to get tied up in a conversation again. Yes. Thank you. Here, I'll leave this stuff to you.
All right. See if you can get back to your desk before the end of the Committee of the Whole report. Committee of the Whole report.
Mr. President, with respect to the budget bill, Senate File 1, the Committee of the Whole heard explanation on Section 350 closed. It took actions on Senate File 1. Do pass.
You've all heard the, oh, sorry. Senator Landon.
Mr. President, I would move adoption of the Committee of the Whole report.
All those in favor say aye. All those opposed? Committee of the Whole report has been adopted. Thank you, sir. We have standing committee reports.
Mr. President, following reports are dated February 3, 2025. Committee number 10, Labor, Health, and Social Services, to whom was referred Senate File 172, Physical Therapy Licensure Compact, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Barlow, Hutchings, and Scott. Excused, Senators Crum and Steinmetz. Senator Barlow, Chairman. Committee number 3, Revenue, to whom was referred Senate File 177, Primary Residence Property Tax Fund. Respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators French, Ide, McEwen, and Pappas. No, Senator Case. Senator McEwen, Chairman. Committee number 3, Revenue, to whom is referred Senate File 163, Partial Tobacco Products Tax Repeal. Respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators French, Ide, McEwen, and Pappas. No, Senator Case. Senator McEwen, Chairman. Committee number 1, Judiciary, to whom was referred Senate File 22, Ground for Termination of Parental Rights Guardianship. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Craigle, Crum, Kolb, and Olson. Excused, Senator Hicks. Senator Olson, Chairman. Committee number 1, Judiciary, to whom is referred Senate File 100, Child Witness Courtroom Procedures. Respectfully report same back to the Senate with the recommendation that it do pass amended. Ayes, Senators Craigle, Crum, Kolb, and Olson. Excused, Senator Hicks. Senator Olson, Chairman. Committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 155, International Physician Licensing. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Barlow, Hutchings, and Scott. Excused, Senators Crum and Steinmetz. Senator Barlow, Chairman.
Thank you, Randy. Speaking of Senator Barlow, do you have a re-referral for me by chance, or two?
That's a good question. Mr. President, apparently I do have two re-referrals. Mr. President, if I could, I would like to re-refer Senate File 155, International Physician Licensing, and Senate File 172, Physical Therapy Licensure Compact, to your committee number 2. Thank you, Mr. President.
Thank you. Without objection, it is so ordered. Senate File 152 and Senate File Senate File 155 and Senate File 172 have been re-referred to Committee number 2, Appropriations. Okay. Any other announcements from standing committees or messages from the House or nothing? Okay. Back to you, Madam Majority Floor Leader. That clears the desk.
Mr. President, I move that we stand adjourned until 10 a.m. Tuesday, February 4th, 2025.
All right, 10 a.m. sounds good. Any announcements? Chairman Anderson.
Mr. President, your favorite committee, Senate Minerals, Business and Economic Development, We'll meet Wednesday upon noon recess, Capitol Extension Room W4, and we'll hear 3 bills. Senate File 134, which is a continuation from today, and Senate File 154, Industrial Wind and Solar Projects, hearing deadline. Senate File 179, Sage Grouse, Compensatory Mitigation Amendments. Thank you.
Thank you. Senator Olson.
Thank you, Mr. President. Your committee number 1, Judiciary, will meet tomorrow upon noon recess in W2 to consider 4 Senate files. Senate File 157, Department of Family Services Confidentiality Amendments 2. Senate File 160, Treatment Court Amendment 2. Senate File 124, Illegal Immigration Identity Report, Detain, and Deport. And Senate File 180, Supplemental Budgets Limitations.
Thank you. Senator Landon.
Thank you, Mr. President. Your Travel, Recreation, Wildlife, and Cultural Resources Committee will meet tomorrow morning, 8 o'clock in W4, that's the Wind River Room, to take up Senate File 132, Protecting Critical Infrastructure and Systems from Drones, Senate File 164, Pari-mutuel Rodeo Definitions, and Senate File 170, Grizzly Bear Management Prohibition.
All right. Any other announcements? Seeing none, you've all heard the majority leader's motion. All those in favor say aye. All those opposed, no. Senate shall stand adjourned until 10 a.m. Tuesday, February 4th.